Okay.
Mention. I have prayer for listing of an AB, my lord. Tomorrow is possible, my lord. Deep.
May I pray, your Lordship? Lordship, item number 12 of today's list, can it be taken up on the 30th or the 31st of this month, Lordship? As Borali has some personal difficulty today.
Adjournment. This is the matter on 3110.
Lordship, is an interim order that may continue.
The interim order granted by the order dated so and so,
6/8/25.
6/8/25. Stands extended to next date.
Obliged, Lordship.
Item number 14, my lord. This matter will be taken up at 2, my lord. I have some difficulty right now.
Okay, second.
May I please, my lord? My lord, I pray for listing upon BA, my lord, regular bail application tomorrow, my lord, for motion.
Some urgency is there.
Yes, my lord. My lord, his wife is pregnant and so there is some complications, my lord. She was admitted in ICU, my lord.
Senior bench is not available, no, thus. Senior bench, not available. You have to mention before the senior bench. Okay. New matters kindly mention before the senior bench, unless it is
May I please, your lordship?
previously rejected by this court.
So, I would like to pray for a listing of an unlisted matter, my lordship. Yesterday, your lordship was pleased to allow the mention, my lords. There is some technical difficulty, it could not be listed, my lordship. One matter listed by item number 64 today in supplementary list, my lordship. That may be tagged with 64, my lordship, and fixed at 2 PM, my lord.
No, you have to mention before the single senior bench is available.
On my-
Justice
but
Nair.
Yesterday, your lordship was allowed the other, which is listed before your
Because
lordship,
yesterday it was not there. Yesterday,
item
the
64
bench was not there.
my lord.
Anyway,
21 night. 21 Bohane.
hello,
Allowed, highly obliged, my lord. I'm grateful.
new matters kindly list before, mention before the senior bench.
May I please, Lordship? Lordship, I beg to mention item number 34, Lordship. As per my instruction, this matter already been charge-sheeted, Lordship, and registered as PRC case number 208 of 2025.
So,
And the matter, that PRC matter is fixed on 31/10/2025. So I may be allowed to withdraw this matter. Just one observation, Lordship. I may be allowed to approach before the trial court, and on that day, I may be allowed to go in appearance bail. Because I am already here in interim bail, Lordship.
you're on interim bill, though, so this has to be disposed of.
Lordship.
Okay, let it come up. Let it come up.
Lordship.
Don't take much time. Let it come up.
May I please, my lord? I would like to mention item number 13 with the consent of the other side. My lord, a compromise has been arised between the party. So my lord may kindly adjourn this matter for 4 weeks, my lord. In the meantime, everything
No.
gets settled.
Learned counsel submits that the parties have arrived at a settlement and seeks a 4 weeks adjournment, which is allowed. This is the matter after 4 weeks.
Deeply obliged, my lord.
May please, your lordship. I beg to mention item number 40, my lord.
4-0.
Yes, my lord. CD is called for, but perhaps CD is not available. May I pray for any other date, my lord?
Not available, CD.
Yes, my lord.
Yes, my lord, CD not available. Petitioner is in interim, my lord.
My lord, I
Case
mean-
diary is not received. Issue reminder, interim bail granted by so and so.
On-
Till the next date of listing, list on
On my lord, 13/11, my lord.
13/11.
Highly obliged.
Lordship, in item number 22, I have filed an additional affidavit, Lordship. Okay, that kindly be called.
May I please, lordship? I beg to mention item number 45.
45.
CD was called for, perhaps CD not there, my lord. No, my lord, case diary not received. no.
Case diary not received. 45. Issue reminder. Are you on interim? Interim, interim bail is not there. List the matter,
On 30/10, my lord.
30/10.
May I please, your lordship? Lordship, I beg to mention item number 37. Lordship, CD is not available today.
37. Not received.
Lordship, interim is
Issue
there.
reminder for case diary. Interim bail will stand extended. Date
13/11, my lord.
13/11.
So interim is there.
Yeah, that will be extended till the next date of listing.
May I please, Lordship?
Good morning, sir. Sir,
Yeah, go ahead.
Lordship, on behalf of the legal aid counsel for the respondent number 2, Lordship, I beg to mention item number 54 for adjournment. We have taken consent, yes, sir.
54,
Yes, sir.
another day.
Can it be fixed after 2 weeks, Lordship?
Can learned counsel fix an adjournment of the matter, submitting that it may be posted after 2 weeks. Prayer is allowed, list after 2 weeks.
2 weeks, Lord. Deeply blessed.
Good morning, sir. I wish to mention item number 74 from the supplementary list, sir. 160. criminal
74,
action petition.
74.
Yes, sir. For early hearing today, sir. 6 dates and 5 courts has been changed, sir. If it can be.
Oh, so you are appearing in person.
Yes, sir.
He had earlier also he had appeared.
Yes.
What can be done? Hearing today, it is on supplementary list, right? What can we do? Go through item 74, petitioner in person. Yeah, should we file an early hearing petition?
Yes, let.
Showing some urgency.
Yes, let him file and.
That option is there. You can file an interlocutory application for early hearing so that, you can jump the queue if it is allowed. Otherwise, I can post it on another day. But if it is, we can fix it on another day in such a way that it comes in the main list.
Yes.
That we can do. If that does not work, that option does not work, then you can exercise that other option which I mentioned, file a, interlocutory application for speedy expeditious hearing, giving reasons, right?
Yes.
Yes.
So this time, should we seek an adjournment? It may not reach, you said, no? List the matter, you can suggest a date
My lord,
so that it comes in the main list.
mainly. Yes.
As part of.
411,
411.
is it okay? 411.
Thank you, sir.
May please, Lordship, I beg to mention item number 16. I'm from, for the informant, respondent number 2. Lordship,
68.
16, 16, Lordship.
Once.
LCR not received, Lordship.
Mhm.
Lordship may kindly adjourn the matter for 2 weeks.
You are the respondent.
Respondent number 2.
I think because have you informed the other side?
Yes,
If you inform, they have no objection.
inform the others.
Learned counsel, Mr. Das, no? You-
NJ Das.
NJ Das, appearing for respond number 2. Submits that with the consent of the other side, he is seeking an adjournment for 2 weeks. The scanned TCR is also not received. Stop. Issue reminder for the same. List the matter after 10, you can fix it after 10 days. Huh?
1911,
No, it will be a little late. BA, no, it's
BA then. On KTL, on 1111.
11/11.
Yes.
You inform, huh? You inform the petitioner counsel that, tell him the date, right?
May
Highly
please, Lordship. Lordship, I beg to mention item number 69. Supplementary cause this matter. Last occasion, Lordship directed the additional PP to take instructions as regards service of notice upon respondent matter. But that instruction perhaps has not been received. So my prayer is that if Lordship can be fix the matter tomorrow, man. And in
Just-
the meantime, PP can take instructions, man.
Just a minute. Tomorrow or maybe Monday. Right.
Monday.
So the instructions, it is submitted that instructions have not yet come. And 6, full stop. Instructions have not yet been received, full stop. List the matter on 27/10.
CD has been received in this case, panel.
Case diary is available and shall be retained Monday.
Monday, man. Indeed.
May it please your lordship. Lordship, I'm praying for listing of a bail application on tomorrow, my lord.
More, it's a new matter, kindly you have to mention before as per the practice direction, you have to mention before Justice Nair, senior bench.
Lordship, this is, as per roster, this bench is taking this matter, your lordship.
Senior bench, you have to, isn't it? Mention before senior bench. You have to mention before senior bench, mention at 2 o'clock.
Deeply obliged.
May I please, your lordship, item number 59, lordship, earlier 3-4 occasion matter was listed, this is bail matter, lordship. So kindly matter may be taken after completion of the bail hearing, lordship.
See, there are other matters also, no? Similarly placed matters. We'll try in the second half. We'll try to make some adjustment in the second half, okay?
May it please your lordship, it's a mention for the AB matter, my lord. Your lordship has passed an identical order in this matter.
Subsequent petition you can
Tomorrow,
file
my lord.
on Monday. Already pending.
Email petition 739 of 2025.
It's allowed on those lines, amalgamation allowed.
My lord, deeply obliged.
Is it not AB, Bail Element, AB should be first one. Yeah, last was alphabetical.
May I please, your lordship. This is regular bail application, lordship.
Yeah.
I am appearing on behalf of A.S.A. Ahmed, lordship. And as on today, lordship, 35 days and 7.6 gram of heroin, lordship, recovered. And he is the consumer, lordship, and he is consumed himself, lordship. But apparently, lordship, FIR disclosed that he is a peddler, but he is not a peddler, lordship. So, well, as on today, 35 days.
CD along with the FSL report will be required.
Call for the case diary heard. So, call for the case diary of Orpeta PS case number 338 of 25.
For that,
The accused is stated to have been arrested on 19/9/2025. Case diary along with FSL report if available. Please the matter.
On 7th of November. lordship.
little earlier, lordship.
I have the calendar, 7/11 or at best 4/11.
Lordship,
4/11.
deeply obliged, lordship.
May it please your lordship. My lord, here, my lord, no wording, because the FIR is quite lengthy. The brief history has been given in the forwarding. This is regarding embezzlement of money amounting to 25 lakhs. He was serving as an accountant in a company, in a store actually, which is a registered company,
Right.
for sale of Royal Enfield motorbikes and accessories.
Mhm.
So they lodge an FIR. They say that while the scrutiny was carried out, it was found that the accountant, that is me, along with the cashier, has embezzled an amount of 25 lakhs, which has been found till now, and perhaps it might increase to certain more once the CA is done with the audit. Now, your lordship will see at page 28.
Let me see the forwarding ones.
Page 27 onwards, lordship, forward.
27.
Twenty-seven onwards.
Yes, 27.
Yes.
Brief history of the case. On 21st August 25, the informant Arun Kundalia, General Manager of 4SS Retail Private Limited, address 03 opposite AIDC Guwahati, submitted a written petition stating that 4SS Retail Private Limited is a company engaged in the sale of Royal Enfield motorcycles and allied products from its registered office in Guwahati. The accused persons, Mr. Vishal Jain, that is me, employed as accountant, and Mr. Santosh Gupta, employed as cashier, were entrusted with fiduciary responsibilities in relation to the company's finances. Their duties included receiving payments from customers, issuing receipts, maintaining financial records, and depositing the collected amounts in the company's designated bank accounts. On 19/8/2025, during an internal financial review, serious irregularities were detected. Scrutiny of records revealed that the accused, acting in collusion and with dishonest intention, had diverted and misappropriated customer monies instead of depositing them with the company. The preliminary assessment indicates a misappropriation of approximately 25 lakhs, though the extent of the fraud may be much higher, warranting a detailed investigation and forensic audit. Now, my lord, the charges, all of the charges are bailable except 3164, cheating. And that also 3164 and 344, the punishment is up to 7 years. Now, your lordship would kindly come to page 28. At the very bottom, your lordship. They say that further the punishment period of sections under which the instant case has been registered is 7 years, and as such, the question of complying provision of notice under 35(3) of BNSS comes into existence. However, in the instant case, the provisions of notice under section 35(3) could not be complied against the below noted persons under the following grounds. Looking into the gravitas of the case where an amount of 28 lakhs rupees is being embezzled by the accused persons, which is yet to be recovered, and in such circumstances, the provisions of notice 35(3) could not be complied. Moreover, in course of investigation, there is a reasonable apprehension that the embezzlement of amount figure may tend to increase as indicated by CA, who is still conducting an audit of complainant's company, and in such circumstances, complying the provision of notice 35(3) in respect of accused as noted below will not only jeopardize the investigation, but the accused persons will for sure try to taint computer other accounts related evidence to safeguard and protect their personal interest. Now, my lord, I'm no longer working there. Obviously, the company won't allow me to work there once such things. The question of tampering with the evidence doesn't come into play now. And why I have pointed out that the FIR was filed on 28th, and thereafter on 1st it was registered. I was arrested on 11th of September. All this while, Your Worship, the investigation was carried out. In the forwarding, they have stated that Caesar witnesses, all other witnesses, the complainant, everyone's statement has been recorded. And I was also called twice. I went there, I gave my statement.
Thereafter you were arrested.
My lord, 35(3), that is not the excuse which they are to give, my lord. And the check, I can take Your Lordship, the checklist also, it's empty.
Anyway.
And
but,
42 days, Your Lordship.
Diary has to be seen, right?
Yes, Lordship, at this stage.
Anyway.
Well, in that case, Your Lordship, the other co-accused, his matter is fixed on Tuesday, 28th of October.
We can try.
Yes, Lordship.
Is the matter, call for the case diary of Gitanagar, PS case number 68 of 2025. List the accused was arrested on 11/9. So list the matter on 28/10/2025 along with BA number
3342 of 25.
3342 of 2020.
God bless you.
Yes.
May it please Your Lordship. Case diary may be called for, my lord. NDPS commercial consequences.
CP along with FSL report. Lordship.
Along with, if available. But S Navas and SH for call for the case diary of Tukchar, PS case number 42 of 25. That's when so the accused.
Tenth,
Rakib Ali was stated to have been arrested on 1/7/2025. Case diary along with FSL report if available.
10th of November. Lordship.
Is it okay?
Well,
10/11.
I'm deeply obliged.
Obliged, Lordship.
This is regular bail application, Lordship, and the sub-plea list, Lordship, item number 63 is out of same FIR, Lordship. And court is already grant bail by your Lordship and the similarly out of same FIR, same forwarding, Lordship.
63 also you are appearing or
Lordship,
you are
both I am appealing, Lordship.
here the-
63 and 5, Lordship,
It
and
was-
as on today, Lordship, 91 days in custody,
It
Lordship.
was already rejected by this honorable.
This was, some people were given
Lordship, this is the order I am providing, Lordship. And kindly come to, Lordship, take the serious item number 63, Lordship. I have annexed the order, Lordship.
Let the matter be come up along with item number 63. then.
63.
Yes.
This was
But this was earlier rejected. by this honorable.
completion of investigation. It was investigation is completed. On that
Yes.
ground, some co-accused were granted. bail.
Yes,
Lordship, I have annexed, Lordship.
Along with that, 63 will take it up.
yes.
In the course of the day, don't worry. Take it up together.
Lordship, both are motion, Lordship, can, Lordship. Obliged, Lordship, obliged.
May I please Your Lordship? The regular bail application, the petitioner arrested on 12/9/2020, the NDBA check out. Under the section 20B2 and B.
Ganja?
7.42 kgs of ganja, Lordship.
And a 7 kg is recovered from his custody.
Intermediate quantity, Lordship. CP
Intermediate.
along with FSL will be required.
7 kg.
41 days, Lordship. Now it's-
Mr. Nath,
Lordship.
DC Nath, and SH for. When can we have the case diary?
Lordship,
Support
on-
gram.
on
Support gram
7th,
PS case
Lordship.
number 52 of 25. arrested on 12/9/2025. Ma'am, can you repeat? Which date?
7th of November.
7/11. List matter on 7/11.
Of Thursday.
Alright.
Maybe, and 7 can take after some time, my lord.
Sabha Pai.
After some.
Obliged, my lord.
Wait, please. At this stage, diary may be called formal. Kunjana?
Guwahati GRPS case number 141 of 25. Within bracket GR number 4478 of 25. Charge sheet case.
No, madam, under investigation.
Investigation. Along with FSL report if available. The arrested on 9/10/25.
On 13th of November. Lord Ship.
And first remanded on 10/9/2025.
Okay. In fact, my lord, there is a small mistake in the cause title, my lord. It ought to have been, my lord, 10/9, my lord. He was arrested on 10/9, my lord.
Oh, sorry, 10/9.
10/9, my lord. I have made a mistake. my lord.
And remanded on the same day.
Yes. So, but can it be, my lord, on
10/9.
can it be on, my lord, on 6th of November, my lord? It will be 58 days, my lord.
It's a commercial quantity. Lord.
নহয় commercial নহয়। তাতে কোৱা কথা।
No, দাদা ইয়াতে লিখা আছে।
ইয়াত লিখিলে নহব নহয়। নহয় cost title mistake. Lordship, I have a look at my lord.
21C.
Page 26 for a once, my lord.
Might mistake.
Also always
because
look
in the
into it.
cost-
No, page 26 is one.
Don't worry. At that time, we'll look into it.
No, the fact,
But I will see it now.
yes, but the fact is that, my lord, police has registered the case under C, my lord, commercial. But if your lordship turns to page 26, my lord, the
237.
inventory, my lord, your lordship will see, my lord, net
237.
weight of the seized heroin is 237 gram. So it's below 250 gram. That's why I'm praying for, my lord, 6, my lord, it will be 58 days.
Lordship on 6th.
6th?
Yes, Lordship.
I am obliged.
6/11.
Sir, sit with. Heavy as a number.
May please, your lordship. So, TCR may be called for lordship.
Boxo matter? No. Commercial quantity.
Lordship,
PRS.
NDPS commercial quantity.
Right, PRS. It is at the stage of investigation.
No,
No, lordship, charge sheet.
Charge sheet difference. Trial is not started.
No, it's a recent matter, recently considered.
Call for the case the scanned case diary and scanned charge sheet of DRI case number 29/, NDPS number.
Lordship, NDPS 307/26.
Case 3 of the which. Accused under so and so section of he was arrested on 33. Please still.
208 days as of today.
Yes.
Pending on litigants, additional litigant session just
One.
wrong one.
From the concerned learned court, that is the court of additional session just number 1, Kamrup Metro.
Kamrup Metro. Deeply obliged.
Take the date. You work out the date. Any date.
November first week, madam.
November 1st, I'll give you that. It will be on 7?
Deeply obliged.
7 then.
May please, your lordship, my lord. This is third application, my lord. Today is 59 days, my lord.
62.
Yes, my lord. Today is 59 days, my lord. The mandatory period will probably be 60 days, my lord.
We'll take instruction whether CS filed or not.
Tomorrow,
Tomorrow, Lordship.
section 69 on the BNS is there, my lord, extend to 10 years, my lord.
And Mahajan, learned counsel, fairly submits that two earlier bail petitions of the petitioner was rejected by this court, by this bench.
Yes, yes, ma'am.
He was arrested on 26/8/2025. SH Bora, learned additional AP, undertakes to take instructions regarding filing of final form in the meantime. This on
Tomorrow, Lord.
tomorrow is the matter
24.
24/10/2020. Right, tomorrow.
Obliged, my lord. Salute.
We do that. Yes. we do.
Lordship, the co-accused already grant bail by Lordship, and sir, kindly take the matter item number 63, Lordship.
I have been
And
informed, Lordship, the matter has been surseated, Lordship.
She did also.
Yes.
Lordship, and page number 23.
Oh, yeah, on that ground, it was
Lordship.
known earlier also. Page 23.
23 of the item number 63, Lordship. Para number 4, Lordship. And charge sheet already been submitted and grant bail, Lordship. So similarly, out of same FIR, same forwarding, Lordship.
Take it on normal. Mom, अपनी मर्जी में type करो। Page है तो item 63, page 22 to south. Same terms and conditions. Same terms and conditions.
Ablash.
What the case? Ita case.
5 and 63.
5 and item 63, page number 22.
Deeply obliged. Deeply obliged.
Yes, post.
May I please, Your Lordship? This is an anticipatory bail application. Your Lordship may kindly come to page 7, is the FIR, Lordship.
Just a At page 10.
Page 7. Is the type copy from English. May I read, Lordship? With reference to the subject cited above, I have the honor to inform you that on so and so at about 9:30 AM, I received an secret information from reliable source that one cattle had been slaughtered for selling its beef at the house of Mondol Sheikh, he is the petitioner, Lordship. So and so, so and so. Accordingly, I have made an GD entry number so and so, and myself along with OP party proceed for taking necessary action. As myself along with OP staff arrived at the house of so and so, and found that beef along with other incriminating articles lying at the premises of the said house. Accordingly, I have seized the number so and so, Lordship, in presence of witnesses. Videography of the seizure process has also been done through e-Saksa. Below mentioned accused person had brought the aforementioned cattle suspected to have been stolen from somewhere to sell them illegally to unknown person for the purpose of slaughtering. Hence, these articles brought to OP campus for further investigation. My lord, I am not denying that I have not done that. My lord, in fact, the cattle, Lordship, is the domestic cattle. Just one paragraph in my petition, Lordship, I have narrated the actual fact, why I have, my Lordship, I have done it. Page 3, paragraph 4. The brief fact of the case is the petitioner has been rearing some domesticated cattle for a considerable period of time. One of the said cattle became paralyzed, whereupon the petitioner, being unable to sustain due to deteriorated health condition, decided to sell its meat. Accordingly, the petitioner slaughtered the said out within his premises. Thereafter, the police conducted raid at his premises and seized the meat and other related instrument allegedly used in the said act. Well, admittedly, this is not a cattle of stolen, Lordship. This was my own domesticated, Lordship, cattle that he has done because it was paralyzed, Lordship. Well, considering the grave of nature of this case, Lordship, gravity of the nature of this case, Lordship, this is a very simple case, Lordship, and so far section IPC is concerned, perhaps, Lordship, this will not attract it. Only section 13(1) and 16 of the cattle, that will come to where, Lordship, the maximum sentence may 3 years up to 8 years. But this is not a stolen cattle, Lordship. It was my own cattle. Well, some protection may be given, Lordship. I'll appear.
Case diary may be called for, Lordship.
For it heard, so and so, M. Khan and SH Boda, 482 application, and the BNSS 23. Seeking prayer is in connection with Kokrajhar PS case 225 of 2025, 225 of 25. It's the red with so and so, Cattle Preservation Act. The Case arose out of the FIR dated 28/9/25. The gist of the allegations is that upon some information, search was conducted at the premises of the accused petitioner, and cow meat was found along with some other equipments. Learned counsel, drawing attention to para 4 of the bail petition, states and submits that the cattle is not stolen and that it was being reared by the petitioner, but due to it becoming paralyzed, he decided to sell its meat. But subsequently, there was a raid at his premises and the meat was seized by the police. Call for the case diary from the concerned police station. However, in the interim, in the event of arrest, liquidate 20,000 with one series, subject to the condition that he shall not hamper and tamper with evidence. He shall cooperate with the investigation and appear before the IO, making himself available for examination. This is the matter. You can
On
hear-
17th.
17/11. Obliged.
May it please your lordship. 482 pay application lordship, praying for pre-arrest bail. The FIR is at page number 14. Lordship, the FIR has been lodged by one police personnel of Gorsuk PS. I am not named in the FIR. Now what happens, lordship? I get a notice in my mobile phone over WhatsApp.
Just a minute.
that-
14.
Lordship.
What is his name?
Shiva Prasad
Shiva
Kumar.
Prasad Kumar.
He's not named in the FIR. He's not named.
And why he says, where is the apprehension of?
He's a,
of this people?
you must have some connection.
Yes, Lord.
Anyway,
Secret river?
you record your statement. You record your statement.
Lordship, I may be protected, lordship, because in the event of it.
Yes, that was.
Lordship, Section 6 of POXO is also incorporated.
What is there? Oh, because of this. Anyway. No, notice has to be issued then.
Yes, Lordship, to the respondent number 2.
Will there be any bar in granting interim because of the notice aspect? He
POXO
can be
matter
given an
is to be
opportunity,
heard.
since he is not named, he
Yes.
can be given an opportunity. I
Yeah.
think that can be given, but we have to issue notice for
Yeah.
final adjudication,
Yes.
right? 482 heard, good name please?
M. Ahmed.
M. Ahmed. S.H. Bora, 482 bail application, VNS. So Gorchuk PS case 216 and 25. আমার কি মানে co-accused of bail of your allegations leakage from them. It's probably Sale law, but the allegation in the FIR dated so and so is file of Harry. As a hard dated 15/9. 15 or 16? 16/9/2025 is about running of prostitution racket in a hotel named Hotel SN Inn.
Thing, my lord, Tiger, that was molded, and on it, he used to do jopo and everything, my lord. And thereafter, those seizures were made. 8, my lord, with my lord, skins of, my lord, what you call the deers, my lord, and 1, my lord, full-fledged, my lord, skin, along with the canine teeth and everything, where he used to do jopo and everything, my lord, that was recovered, my lord. Here, my lord, the factual matrix is quite different, my lord. Here, what has happened? Again, apparently on face of it, my lord, violation of fundamental rights, my lord, but not as regards section 47 and 48, but as regards now 58 and earlier, my lord, 57, it also flows from article 22(1), my lord. Can I come to the arrest memo, my lord? Arrest memo, my lord, with all respect, my lord. It was produced subsequent to 24 hours, my lord, and that too by video conference. And that is allowed, my lord.
36.
Page 36, my lord. Lordship may have seen, my lord.
Yes.
There, my lord, date and time of arrest, my lord. 27/9/25, 10:30 AM.
Good.
Lordship has seen, my lord. So 10:30 AM, my lord. Next day he was produced. The next day he was produced by video conference because he was hospitalized, my lord. That order I am reading on 28, and it was a Sunday, my lord. And the holiday court set around 3:30, my lord. Have I made my position
Yes,
clear, my lord? And the order is at, my lord, page, with all respect, my lord, page 17, my lord.
It's not the IO's fault then, court's fault. Sometimes they see it late. They don't
Yes,
see it
yes,
late.
my lord. The
Because he
IO
was
may
there
have
yesterday.
produced him in the morning, possibly, my lord. 28/9/25.
Yes, yes.
The case record is put up today before me. Accused person, namely so and so, about 46, has been produced before me through video conferencing. So this is date is, my lord, exactly the next day, my lord. But it was a holiday, my lord. It was a Sunday, my lord. And one of my junior friends appeared, my lord. And the matter was taken up at 3:30, my lord. And what the laws, like 47/48, my lord, there's now section 58, my lord. It came from the Constitution 22(2), my lord. May I just place it, my lord? And the, my lord, it says, my lord, Article 22(2), my lord. 22(2), my lord, with all respect, my lord.
IO had brought it. IO had brought the person, but the court sat late, right? IO
Well-
must have brought the person. Anyway, let us see. Let us see the.
My lord, IO did not bring, it was video conferencing, my lord.
Video conferencing.
Video conferencing, my lord, and unfortunately it was a holiday.
10:30, it would have been, 10:30. The court starts at 10:30, right? So he could have been produced at 10:30 dot.
But that was a holiday, my lord. That
Holiday.
is why court did not sit, possibly no fault of court, but only technical, my lord.
Nobody's fault. but
My lord,
everybody's fault.
with all respect, my lord. Article 22(2) says, my lord, 22(2), every person who is arrested and, sorry, my lord.
Yes, go ahead.
Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey. And this journey is, my lord, from Gitanagar. He was picked up, my lord. And Thana is also very nearby, my lord. That will
Yes.
take 1 hour more, my lord. So, my lord, this is 24 hours, and this is incorporated in the statute thereafter, my lord, in section 58 of the BNSS, my lord. Section. And here the word shall has been used, my lord.
Right.
58, may I, my lord?
Yeah.
Person arrested not to be detained more than 24 hours. No police officer shall detain in custody a person arrested without a warrant for a longer period than under all circumstances of the case is reasonable. And such period shall not be in the absence of a special order of the magistrate under section so and so exceed 24 hours. So here it is shall, my lord. And the authorities are innumerable, my lord. This was prior to section when by Prabir Purukayasta and all others, my lord, wherein section 47 and 48 has been dealt with, my lord. In this authority, I am placing, my lord, only one, my lord. There are many others, my lord. 58 has been settled, my lord. Sorry, my lord, earlier 57, now it is 58, my lord. This is Subhas Sharma, the Directorate of Enforcement by Subhas Sharma, my lord. Therein it occurs at, my lord, para 7, my lord. May I?
Yes.
The requirement of clause 2 of Article 22 has been incorporated. It goes. It is as regards, my lord. That case was pertaining to
You
PMLA.
are reading which judgment? Manoj?
I'm reading Subhas Chandra, my lord. Manoj is a subsequent one. Subhas, Directorate of Enforcement, my lord.
Para 7.
Para 7 would be regarding PMLA. Even to PMLA, it is para 8, my lord. Once a court, while dealing with a bail application, finds that the fundamental rights of the accused under Article 21 and 22 of the Constitution of India have been violated, while arresting the accused, this is very important, my lord, disjunctive, or after arresting him, it is the duty of the courts dealing with the bail application to release the accused on bail. The reasons is that the arrest in such cases stands vitiated. It is clearly the duty of my lord so and so to uphold the fundamental rights guaranteed under Article 21 and 22 of the Constitution. Here, not only a constitutional right, my lord, but thereafter the statutory right under Article 58, my lord. Oh, sorry, my lord, Section 58, my lord. And there are other authorities, my lord, Manoj, my lord, that occurs at page. If necessary, my lord, the same is reiterated, my lord. This is all, my lord. Prior to that, my lord, that authority I have, para 10, my lord. The police officer who conduct investigation, para 10, my lord. Lordship has found. The police officer who conducts investigation cannot obviate the legal obligation to perform two requisites if he knows that the investigation cannot be completed within 24 hours after the arrest of the accused. One requisite is to transit a copy of the case diary to the nearest judicial magistrate. The other is to forward the accused to such magistrate simultaneously. The only exception, well, this is regarding a foreign alien and, my lord, time. Thereafter, para 12, my lord. If the police officer is forbidden from keeping an arrested person beyond 24 hours without order of a magistrate, what should happen to the arrested person after the said period? It is a constitutional mandate that no person shall be deprived of his liberty except in accordance with the procedure established in law. Close to its heels, the Constitution directs that the person arrested and detained in custody shall be produced before the nearest magistrate within 24 hours of such arrest. The only time permitted by Article 22 of the Constitution to be excluded from the said period of 24 hours is a time necessary for going from place of arrest to the court of magistrate. Only under two contingencies can the said direction be obviated. One is when the person arrested in enemy alien. Second is when the arrest is under any law for preventive detention, NSA, my lord. In all other cases, the Constitution has prohibited peremptorily that no such person shall be detained in custody beyond the said period without the authority of a magistrate. Here also bail was granted, my lord. Only, my lord, he cannot be detained possibly.
The only thing is that my question would be to the prosecution also that where is the material, the law, the statutory law and the constitutional provisions say that he cannot be forwarded to the nearest magistrate beyond 24 hours. So where is the material to show that he was not forwarded within 24 hours? The court sitting at another time is not in the hands of the IO.
Yes.
The statute and the constitutional provisions, to my mind, subject to correction,
Yes, ma'am.
does not say that the court has to take it within 24 hours. Suppose the court takes half an hour late,
Yes.
but the person forwards it in time, but the IO forwards in time, then can the accused be said to be produced beyond 24 hours?
Yes, ma'am.
Can I?
The IO is expected to make those notings in his TOCA, in the seed case diary. From the case diary, you will find
Yes,
that in the TOCA, Anyway, let me go back. So the thing is that let us go back to the order of the magistrate again.
Yes, my lord. Yes, my lord. 17, my lord.
We can bring the case diary, short date,
Oh, my
Tomorrow
lord, can
also you
it be
find
like this, my lord?
itself, my lord.
No, I'm not saying, yes, Lord, he's correct. Correct. My lord, can it be like this, my lord, with all respect, my lord? Here, my lord, say, my lord, in some cases in court, when the time span is provided, my lord, then if necessary, my lord, he may be produced at home also, my lord, with all respect, my lord. Like, my lord, this, what you call that, my lord, the Juvin Guard cases, my lord. Here, my lord, with all respect and forbearance, my lord, if I read 28:9, my lord, then instruction may be sought.
Sometimes take it home also and take it in the court also.
Yes, my lord. Yes, my lord. Very much, my lord. My lord, that instruction may be bought whether he was produced, when he was produced, my lord. Because it was a holiday court, to the PI's office he was produced at after 3, my lord.
If the IO has not produced, then certainly there will be a right accruing
Yes.
in his favor. Certainly.
That will come, my lord.
Should not, that is settled.
Yes.
But these are, nitty-gritties. Like,
Lordship, that instruction he can bring, my lord, from that. I'm not saying seeking bail at the moment, my lord. Definitely, my lord, that instruction he can.
No, I think if there was clear materials.
My lord, can I read the order, my lord? That
There
be
was
better.
absolutely clear to the court that, it was, that he was produced beyond 24 hours. Then it would have been justified to grant
Yes,
interim bail also.
My lord.
So,
And,
if you can wait for a while.
Yes.
My lord, not produced by VC, my lord.
Yeah, true.
That-
VC.
that-
That is the problem, actually. That is the.
By VC, my lord, that will never come.
Permissible.
My lord, permissible in law, my lord.
But first production always better.
My lord, there is a prayer for interim, my lord. If otherwise, my lord, I may be booked. That is one part, and I read the order. as is apparent at page 17, my lord, 28-9, my lord. The case record is put up today before me. Accused so-and-so is about 46 years, has been produced before me through video conference. Nowhere it is mentioned, my lord, that he was produced beyond that period, and it was not raised by the prosecution, my lord. Sorry, my lord, by the defense, my lord. And non-raising by the defense, my lord, that is clarified by Babu Singh, my lord, if I am not mistaken, my lord. Fundamentally, it can be raised at any point of time, my lord. Now it has come to our notice, my lord.
You can.
If it is read in totality, my lord,
Yeah.
nothing as such, my lord.
Okay, when can you get the case there? Gita?
My lord, next week, my lord, 30, my lord,
Monday?
30.
Monday. You should know.
Monday, my lord. Tuesday, my lord, 28.
Can it be Monday, my lord? Anything is over Monday.
Up to him. I mean, I'm
Monday.
ready to take it on Monday.
Monday.
Let's see it.
Monday, my lord.
These are the gray areas actually. These are
Right.
the gray
Yes,
areas.
right.
Actually, it is the duty of the court also to take it within 24.
Within 24.
Sometimes in
Yes.
practical difficulties.
Mm.
Practical difficulties.
It
But
should
the
be-
police has to forward within 24 hours.
Yes.
That's his duty.
Yes.
If he fails, then the person will get a right.
Mhm.
My lord, that query, my lord, possibly, my lord, with all respect and full adherence, my lord. What I'm saying is this, my lord, because by video conference, it is apparent, my lord, the time frame and everything, it was carried out at 3:30, my lord. That is the pertinent thing, my lord. He could have been produced on 27 itself, my lord. 28 was a holiday, my lord, by video conference.
Anyway, try to get you get the case diary and try to see this aspect, okay?
My,
Because this will have a bearing on the.
My lord,
application.
my lord, my lord.
Kindly have a say person council has submitted.
My
You see whether there is any toka to indicate.
yes, yes.
Otherwise, we'll have to
Any-
go by
any-
the order only.
Any note regarding that?
Otherwise, we'll have to go by the order.
My lord, may I just add one line, my lord, if your lordship permits me, my lord. Everything is all right, my lord. What I'm saying, by video conference, my lord, so that he was brought before the court at 10:30, that would never come out, my lord.
Not come. That will not come. If there's anything else,
Oh, that much, my lord.
two interpretations are there. The one beneficial to the accused has to be taken, right?
Exactly, my lord.
Usually one. So anyway, and we no need to write much now. You just write. Call for the case diary of.
My lord, offense report, my lord.
That's how. Forest
No,
Department.
no.
Offense report of
It
TNPR, so and so. The wildlife. The accused was arrested on 27/9. So he's arrested quite some time back.
My lord, only report, my lord.
Report. Call for the report. Get it on Monday.
My lord.
My lord,
Should be
My lord.
possible.
27.
My lord. Highly obliged, my lord. Obliged, my lord.
Let me keep this judgments, huh? Nimish?
My lord,
I
my
will
lord,
keep
my
this, huh? Because we have to learn continuously. Let me take the AB hearings first, because I think we'll be overall faster. We should keep experimenting, I think, to find optimal things, optimal systems, optimal models. I think we'll be overall faster if we take up the AB first. AB, let's see today. AB bail hearing. Let us see, but councils are not intimated, so they may not be available. You know, not say to go tomorrow. Yeah.
May I please, your lordship? Lordship, on earlier occasion, this honorable court is pleased to call for the updated case diary, lordship.
Yes.
So along with the medical report, to that extent, Lordship, the IO of the present case has given a note that he is unable to collect a medical report. He needs some time, Lordship. Madam,
Diary has been received.
diary received, Lordship.
The case diary is received, but medical report, it's a case of, allegation is about abatement, you said?
No, not
Injury,
abatement,
lordship,
Huh?
Injury, lordship.
The injury,
regarding physical assault, Lordship.
or regarding physical assault. Anyway, so case diary is received, however, the IO has communicated that he could not collect the medical report. The medical report shall be procured on the next day. CD will send back or you will
CD will
retain
send
it?
back, Lordship.
The case diary may be sent back and procured again before the next day. The interim order granted by order dated. I always check. it's all-
2705.
27?
05. 2705.
Must be. Okay, right, order dated 27/5/25. Stands extended till the next date of hearing.
Oblige, Your Honor.
Next date of listing, right?
Let the
Take-
matter be on 14th, Lordship.
Four-
14
14 November. Okay. Check. Around 14 plus minus.
Yes, Lordship.
Okay.
Obliged, Lordship.
Oblige, Lordship.
Will, this can be in the record.
And Lordship, that can be kept as a part of.
30, 31, 32, 33.
Correctly. Also, to take over, right? The Lucifer.
Those methods, my lord, CM vigilance, my lord,
Special pick is a bit.
Dancing the S bot is on legs, Lordship. Possible matter for time.
Oh, no problem. I have also changed the sequence actually. You know, the asset.
Lords, this matter already been surseated, Lordship.
In the interim order is there.
Yes, Lordship. Interim order is there, Lordship.
Certified by.
Chartered as well. 482 application. Taking bail for Digboy PS case number 10 of 25. The section. It's 498 acres.
Lordship.
Earlier 498. It's true. The petitioner was granted interim bail on
19/6/2025.
19/6/2024. It is submitted by the prosecution that in the meantime, upon completion of investigation, charge sheet has been submitted.
Lordship,
Oh, he has submitted.
he has submitted. Lordship.
All right. You don't have any instruction.
We don't have any instruction to that.
Lordship, and the matter, this case is already registered as PRC case number 208 of 2025.
Okay. At the time of filing only it was charge sheet.
Yes, Lordship.
At the time.
Then why?
Thereafter, Lordship.
Thereafter,
Not
Lordship.
yet,
Not at the time of filing, Lordship.
Then what should we do? Should we?
Let him be appear before the trial court and trial court will decide in accordance with law.
It is submitted to petitioner some counsel or submission could do. But in the meantime, completion of investigation, that's the case has been charge sheeted, giving rise to PRC number.
208 of 2025.
PRC number 208 of 2025. Where is the PRC number? It is here.
PRC number to code us.
208 of 2025, Lordship.
No, I'm checking from the case record. You must have mentioned somewhere. Well, it came subsequently. No, it happened subsequently. He was not mentioned.
Lordship, that number is not annex here, Lordship.
Not annexed. So will you seek bail from the Learned Court bill? From the trial?
Lordship. Just one observation, I may be allowed to go on appearance bail, Lordship. That line may be.
That will decide it in accordance with law by the trial court. So that order.
No, if there is no dispute with regard to the
Yes.
filing of charge sheet,
Yes,
investigation upon completion of investigation, then I can dispose also. There is no
Lordship.
dispute, but you don't have information, right?
Lordship, to
Don't
that
have
regard.
bail.
That's why Lordship, I'm praying that. the
You
matter
take the
will-
instruction. Then.
Lordship, on last occasion, I also submit the same thing and your Lordship direct them to bring the instruction.
Instruction.
Because next day is 31/10/2025, Lordship.
Is it? I see. The
Yes.
interim bail granted by the order dated 19/6/25 stands extended till the next date of listing. In the meantime, the prosecution, learned prosecution said take instructions. Instructions regarding the completion of investigation as submitted by the learned petitioner council. Must be true, but from their side, let it come.
Lordship.
Lordship, thing is that for appearance, Lordship, next
But
that is
I know, you
31.
told me. Take the instruction.
If it is so, then Lordship may record his statement.
Yes, yes.
If your Lordship
No, no,
wishes.
no, you take an instruction.
I'll take.
I'm keeping it pending.
Yes,
27/10.
27th.
Lordship,
On that, they will dispose it. of.
Lordship.
Yes,
Just a procedural formality.
obliged.
Next.
35.
The first one.
Please, your lordship.
Amicus was appointed. right?
Yes, Mr. D. Gogoi
It.
was appointed. The Marcus. The way CD is available also.
Maybe taken up sometime, after some time, lordship. After some time. Obliged.
If this works favorably of taking AB makes us faster, then I will tell the registry to make a mention in the course.
Lordship.
Because I think the
Gladly.
sequence cannot be changed in the.
Yes.
In this case, my lord, this honorable court, my lord, granted interim bail, my
Yes.
terms of my lord, interim order lordship, I appeared before the IU lordship. Kindly see the FIR lordship at page 12.
Absolutely. Darius come.
26th of CD not received.
CD not received. So let's
Lordship.
get another date.
Your Lordship, is CD not received and I was praying for another date. to submit the same.
Case diary not received, issue reminder for the same.
And petitioner is on interim.
Interim bail granted by the order dated 8/8/25 stands extended till the next date of list. Okay.
Obliged.
On
No, on 14 Lordship.
14/11.
Yes.
Obliged.
My lord, excuse. The petitioner is an interim, my lord, by order dated 21/8/2025. After that, he appeared before you, before the concerned IO matter. This is a case matter where one Abdul Hai matter misappropriated course of money in the name of headaches matter.
In the name of?
Headaches is an app, my lord, online.
Oh.
Petitioner is not a name accused.
Oh, headaches.
And similarly situated persons, but some persons are already granted bail, madam, by this honorable court as well as madam honorable Supreme Court. Supreme Court order is 39, madam. And one madam Deepak Kumar Paul, who was granted interim bail, madam, by this honorable court on matter 4/2025. It is page 43.
All right. Investigation is not completed.
Not complete. Investigation is going on, my lord.
Going on. The order dated 4/2/25 only, passed by coordinate bench, it was observed that there is progress in investigation. Anyway, this kind of cases might take time also. Nevertheless. The petitioner's name is here, is Rupam Kumar.
Rupam Kumar Sarkar.
Upam Kumar Sarkar, my lord. Case diary received, my lord. CD available.
This is. Could you go through it?
Yes, my lord. No, otherwise, my lord, by way of luring all those persons, my lord, if from the, my lord, they were involved in, my lord, all, there are many other accused persons, my lord. The present accused person is one of the employee of that, my lord, app, my lord, that is company, and my lord, the present, there are also, my lord, evidence against the, some of the, I have found, my lord, that he is also involved in collecting money from the, some of the, my lord, victimized persons, my lord. Regarding that aspect, there are statement of the witnesses, my lord. And one Caesar list also I have found in the case diary, my lord. From that, from the residence of the, my lord, the present accused. My lord, this is the Caesar list, my lord. My lordship may kindly.
Main accused is one Abdul. Hai.
Abdul.
Yes, yes, those accused person, Abdul, Hai, those,
He was already granted bail.
they were already granted bail. Otherwise, my lord, it is not that there is no material against the present accused person, my lord. There are material also materials against the present.
But
accused.
Petitioner himself.
On
is the
behalf
victim.
of them also, my lord, there are, because there are statement of the witnesses that he collected money, that regarding that one, your lordship may kindly peruse.
Is custodial examination may be necessary? What do you
Your lordship
feel
may kindly peruse.
on the investigation?
And
The main accused was granted bail by.
Yes.
By this honorable court.
You have the orders. I don't-
My lord, waste 25 minutes.
Caesar list is also there.
The petitioner himself is a victim, my lord. And he's a teacher, my lord, by profession.
He was given regular bail.
My lord, just regular.
Otherwise, his statement is available, no? Statement.
He's a mother,
What
Seven
figure?
mother ready to cooperate, mother. Any. In 21/8.
Cargo order to inside.
Main accused is Abdul Hai and
21/8 release. Huh? Yes.
main accused person is Abdul Hai and other person will receive. He is the employee. Maybe my lord, he collected money on behalf of those.
Some involvement is there.
Yes, yes, some involvement. is-
3, third paragraph line. The present petitioner was granted interim bail on 21/8/2025. He appeared. no?
He appeared. Statement
Which
recorded.
appeared before the IO and his statement has been recorded. The case diary has been received and it indicates extensive investigation, which however is not yet completed. Full stop. The learned additional PP submits that the investigation has revealed some incriminating materials against the present petitioner as well. Peruse the statements of the witnesses pointed out. Drawing attention to the annexed orders in this regard, copies of annexed orders in this regard. The learned counsel for the petitioner, Mr. Khanikar, submits that several co-accused have been already granted bail. So let him go then,
Yes.
subject to conditions.
Yes.
In the, considering the said aspect of the matter, the cooperation rendered by the petitioner, as well as the progress of investigation, dash, I am of the considered view that it may not be necessary to cancel the interim bail, and that making it absolute may not prejudice the investigation in any significant manner. In such view of the matter, it is the interim bail granted by order dated so and so is hereby made absolute, subject to the conditions that number 1, he shall continue cooperating with the investigation. He shall not hamper or tamper with evidence. He shall not misuse his liberty to commit any offences. Number 4, he shall be available for trial if one commences against him. Return back the case that the petition stands disposed. Did go.
Time being 35.
The second application, Lordship. FIR page 10, Lordship.
Yes, sir. তুমি ইনফরমেন্টর হবে আর রিজেক্ট করেছেন এটা
Actually, Lordship, in this case, Lordship, there's a love affair between the victim girl and the petitioner, Lordship. And the parents of the victim girl, Lordship, reluctant to give marriage to me, Lordship. And subsequently, this affair has been lost, Lordship. In fact, there is no such incident happened, Lordship, but have been stated in the FIR, Lordship. Complete false allegation, Lordship.
25/9/25. The petitioner appeared before the IO and his statement has been recorded. However, learned counsel appearing for, you are appearing for the, this, what is the department of counsel? No,
It's
the additional PP.
additional PP
Oh,
law and this.
and thus, additional PP submits that though case diary has been received, but the said statement is not reflected therein. The case diary may be sent back and procured again with the up-to-date investigation, including the statement of the petitioner. The interim bail granted by the order dated so and so stands extended till the next date of listing. Any
10,
further?
11, Lordship.
10,
10, obliged.
10, 11. Yes.
Lordship, in this matter, my senior is unable to appear that he has had fever
Another day?
another day. And
Diary-
interim may be
Yes.
granted.
I've seen.
Lordship,
Diary has,
diary received, Lordship.
it has been received.
Yes, 42, no?
Your good name?
Kate Ayak.
The learned counsel seeks an
42.
adjournment as the leading counsel is stated to be unwell, prayer allowed. The case diary received shall be retained. The interim bail order dated 19/9/2025 stands extended to the next date of listing. When do you suggest, since case diary will be retained?
On chip on 30th.
30?
Obliged.
Please, your lordship. Lordship, I'm on interim bail. The updated case diary has been called for. I appeared twice before the police station. And all the other accused have been granted regular bail.
Retain করব. In this case, lordship, though the CD we have received, lordship, but as my senior has stated that they are on interim, but I have not seen the statements of the
Appeared twice.
But I have not
It's
seen
not
him.
reflected.
It is not reflected, Lord, so we need to update it, Lord.
Third, I'm senior counsel, I am authority. So who submits that pursuant to grant of interim pre-arrest bail on 26/9/25. The petitioner herein has appeared before the IO on 2 occasions. Full stop. And his statements also have been recorded as per the instruction. Full stop. The learned, yeah, good name.
KK Das, Lordship.
KK Das, learned additional PP. Submits that though case diary has been received, but the same does not appear to be updated. And also, the said statements of the petitioner have not yet been incorporated. The case diary may be sent back and returned with updation. Stop. The interim bail granted by 26/9 stands extended to next date of listing. You suggest
On 18/11, Lord.
18/11.
18/11.
Otherwise, Lord, 14/11 then. Lord. 14.
You got a friend. Obliged.
Lordship, this is an anticipatory bail application. CD was called for in the last.
Lordship, CD we have received, but I need some time to go through it.
She needs some time. After some time, we'll take maybe second.
Earlier occasion CD was received, your lordship, service report was awaited.
Service report awaited, Lordship. Service report not received as per the order dated 17.
Could you take instructions? Not received. Case record was called for?
No,
Or
no.
the investigation?
CD is
CD.
available here.
CD is it, but
CD is
service
available.
report awaited.
Can you take instructions now?
Lordship, next week, Lordship.
You
and-
take instructions, right? The petitioner was granted interim
No interim, your lordship.
is not there. So the case diary is available, but service upon the informant implemented as respond number 2, not yet completed. The petitioner, learned prosecution shall take instructions regarding the same before the next date. This is the matter on next week,
Lordship,
30 or 31?
31, Lordship.
31.
30. CD to be written.
CD to be written.
Obliged.
She been on 30th.
Lordship.
30th.
Lordship.
This time, 30th.
30.
Not 31.
Okay. 47? Yes, 47.
Wait, please, Your Lordship. Lordship, last occasion CD was called for in this.
My lord, case that is available. My lord, here in this case, lordship, this petitioner has been called as a witness only.
Yes.
It's someone.
Yes, my lord, but being a central government civil servant, my lord, always this apprehension. Yes, my lord.
Because he's a witness. I think apprehension is not there, my lord.
179.
171, your lordship, can listen to
179.
179.
Page 31, my lord.
So grounds of reasonable grounds for believing that he will be arrested is not there, my lord. 179. Notice under section 170.
If a person is called as a witness, he's usually not arrested.
No, that's not. Why should you arrest?
My lord,
Otherwise, how will they cooperate?
usually they don't.
Usually,
My lord,
but there
this
should
is-
be a law that if you're
But there's always a belief.
your position has to be changed, then only you can be arrested.
Otherwise not, man.
My lord, but there's always an apprehension in this matter because being a
I say.
central government.
I'm
servant-
saying as a layman, there should be some provision that if you are called as a witness, as long as you are cooperating, you cannot. Anyway. So this can be disposed of.
This was nothing, my lord, there.
Disposed of. Stop. Mr. J. Singh, learned counsel for the.
He was asked to join the investigation only, my lord.
Some interim order is there? No.
No, my lord.
Second, D69, second paragraph close. Mr. Singh, J. Singh, learned counsel for the petitioner submits that though he has been called by the investigating authority as a witness, but he's having apprehension of arrest and therefore it's preferred this petition. Good stuff. E. Kotogi, learned standing counsel, the prosecution, being CM Vigilance, within brackets CM Vigilance, submits that the petitioner, as rightly contended, the petitioner has been called as a witness. And all he has to do is join the investigation, and that there is no basis for his apprehension of that. So what should be done then? Disposed of as non-maintainable or?
Non-maintainable, my lord.
Huh?
Not
You
maintainable.
want the order?
My lord, he was supposed to be appearing on 22nd of last month. My lord, he's ready to go and help with the investigation this stage also. My lord, only in case of his arrest, if he may be.
He cannot be arrested, my lord, because necessarily because when he is cited as a witness.
My lord, दादा दुपुरो case for a kakukul. My lord, this is again a starlighted case. So my lord, everyone who is.
The case is about disproportionate income, your lordship, can you see? He will come and only depose regarding the income.
Should not be. Actually, it is not, there's no need actually. You really want to order. It's not necessary actually. In the event of his arrest, then condition have to be imposed. Why? Because you are a witness. Join the investigation.
Join the investigation. Merely witness, my lord.
My lord, I have already crossed that line on which I was called for.
Anyway, we will look into it, my lord, but let him appear within 10 days, whatever it is, 7 days.
In the context of the aforesaid submission of the learned prosecution, I find force in the said contention that as the petitioner has been called as a witness in the case, his apprehension of arrest is baseless. Therefore, this petition would be not maintainable in the present form. However, the petitioner is directed to cooperate with the investigation and appear before the investigating authority and render assistance as a witness. And in the event of his doing so, no coercive measures will be taken against him. That will solve your problem.
Because the case of disproportionate is said, but therefore, how can it be?
Definitely, if somebody is helping the agency. as a
Abatement is
witness,
there and
why
disproportionate.
should be? Otherwise, nobody will come. Anyway,
Obliged.
this will
Yes,
take
ma'am.
care of your
No questions.
concerns. Disposed of the aforesaid terms. 48. Complete many.
48 lordship, service report awaited lordship.
My lord,
The
today, my lord, I have submitted Okalasma on behalf of my lord, respondent number 2, my lord.
Okay, you have
As a
entered a
complaint
plea.
with that. There is the mother of the victim, my lord.
It's an investigation stage case or
Yes, lordship.
investigation stage? You kindly furnish him a copy. Weekly. You furnish him a copy and we'll take it after 2-3 days. Right?
Exact my.
Case diary has been received.
It is.
The case diary has been received. Further, Mr.
Yes, Ahmed.
S. Ahmed, learned counsel, enters appearance on behalf of the informant, impleaded as respond number 2. And full stop. He shall be furnished with copies by the petitioner side. The case diary be retained. List the matter on Tuesday.
No.
Tuesday, you can take it. You have some difficulties. Tuesday.
Tuesday is 28.
Or Monday.
20s, is it possible on 27th, my lord?
No.
I am deeply obliged, my lord.
Obliged.
Yes, sir. Supply AB bill hearing 9. Kedna, sir. Okay. Low and long break. 5 minutes, huh? Just.
Whether section 27A, my lord, attracted or not.
Oh, that's one. This is the AB.
71. It is 71.
Along with connected matter.
No, no, sir, this is 70, 71.
Item 17, so.
Our item is 71. This is not our item. This is 70.
AB tomorrow.
This is 70.
Oh, sorry, my lord.
This is not the.
This is a different matter.
This is 72. No, 70 case diary not received, my lord.
My lord, say, in respect of 70, my lord, this last order was there, my lord. In the last order dated 17/10/25, it was directed by this honorable court to the prosecution to bring the latest report from the OC.
Regarding service. Case record is available.
This
Case
scan
record
copy already available, ma'am.
Yeah, I think it is available.
No, after some time, my lord. And regarding report also at 2, my lord, I will also.
My lord, in this case, along with this case, the case number, my lord, 67 is also there.
Well, some other, my lord, otherwise some other day, my lord, not today.
67, my lord, 67 and 70, 70 AB and 67 is a
67
BA, my lord.
Take a chance today. If not, then another.
Only my lord, amicus curiae is to be appointed, my
No,
lord.
no, service. We just have to confirm the service.
Yes,
Then
whether
we can
service
act.
completed.
Then I can appoint them. 71.
Yes, 71, my lord, may kindly be taken up along with item number 68.
68.
68 of BA, my lord.
Okay, much of it.
That's what BA structure. Right,
Your lordship remembers that your lordship has accommodated on the last occasion.
Yeah.
So, my lord, there are few matters which they can, because I am in court number 1, item number 1415, the Mizoram matter. So, my lord, they can start, your lordship will take up. One matter, I have seen that your lordship rejected one bail application. That I have to say first, my lord. There are few cases which has been filed. Your lordship has rejected.
One is a subsequent petition.
Yes, sir, your lordship rejected bail, and few cases has been granted absolute in some other courts. But one matter has been rejected by this court.
We take up that matter first. What do you say?
One matter is rejected, so I have to say first before this court. Rejection by this court is
Which item number? That one?
not in this case, in other case. 1456 of 2025. That has been rejected, pertaining to the same FIR.
Another
1456, your lordship will note down, of 2025.
AB.
AB.
1456.
That is, your lordship will, Ananya Bhattakur. ANANYA, Ananya Bhattakur. And there are two cases which have been made absolute. One is, my lord, AB 1264. 1264 of 2025, absolute, and AB 1457 of 2025 is been absolute, pertaining to the same FIR.
Conflicting.
And AB 1278 of 2025 is pending. AB 1324 2025 is pending, and AB 1464 of 2025 pending, and AB 1663 of 2025 pending.
Yeah.
So all interim bail was granted, but I'll tell your lordship before I open.
All the cases interim is given.
Interim is there, my lord. Till my lords, my lord, I'll tell your lordship the statement has been recorded. Statement has been recorded, and because I have to say first that which bail your lordship has rejected.
Yes.
That's why
No issue.
I told your lordship this is what your lordship has rejected. Now 2-3 things are there, my lord, in this case. What I felt that when I moved this matter, my case was that if your lordship takes up 1464 of 2025.
Mona Lisa.
Yes, mine is a bit, I think item number 32, but I am taking the privilege of arguing first because there is one matter which is may come up.
No, sir.
With your lordship permission, my learned friend,
Really, come on.
which are here before this court. My lord, the all other case which my learned friends are moving, these are all, they were candidates and subsequently they have been promoted. And my lord will kindly note down the FIR which has been lodged is of 2025 if your lordship looks into at page 18. Yes. Kindly see the lodging of the date of the FIR.
Yes, 15/5/25.
15/5/2025. Your lordship will kindly see. That's very relevant. At page 20, the contents of the FIR, if your lordship will kindly see para 2. Lordship will see para 2 of the FIR, contents of the FIR. See para 2, my lord.
Yes, I'm on para 2.
Yes, it is to be noted that a serious allegation was made by Sri B.J. Sharma. I don't know who is that B.J. Sharma, regarding the illegal appointment of 8 posts in the rank of Assistant Tourist Information Officer in the Directorate of Tourism Assam during Sri Rakibul Hussain tenure as Tourism Minister in the year 2010-11. So of 2010-11, my argument is that I'll say straight away, my lord, is a political motivated because this person, Rakibul Hussain, was there at that relevant time. Minister of Tourism for 2010-11.
Right.
Now, like I just see next, these appointments were purportedly made under Srimati Mona Lisa Goswami directorship. This is the petitioner before this court, which I am moving. See, now she has retired. She is an IS officer. She was the then, my lord, director under Mona Lisa Goswami. My lord will kindly see next comma, based on ministerial recommendation. As per approval of the Honorable Chief Minister so-and-so, dated a regular inquiry was initiated, so-and-so, so-and-so. Now, my lord will kindly see 3. There are few members, kindly see selection of candidate for the post of Assistant Tourist Inform was formed comprising of following member, Mona Lisa Goswami, we are petitioner, Dimbesa Saikia, Deepak Mazumdar, Navajyoti Bora, then so-and-so. Except Mona Lisa Goswami, my lord, this person has not been aired as an accused in this case. This will be my second argument, my lord. Whether they could have. I'll straight away show one judgment of the Supreme Court they could not have. I have been a scapegoat because they were also a party to it. During inquiry, it was found that the advertisement was published for filling up of 8 number of posts in the rank of Assistant Tourist Information Officer. Reservation as per advertisement was as UR number so-and-so. If your lordship come to page 21, kindly see paragraph 5. 3 paragraphs. During inquiry, it is found that written test for the post of Assistant Tourist Information Officer was held on 26/2010 at 4 different venues, namely Panbazar Girls Higher Secondary School, Guwahati Kamrup Academy, so-and-so, Assam Railway Higher Secondary and Bengali High School. During inquiry, it is found that Director of Tourism Assam declared the result of written test for the post of Assistant Tourist Information Officer held on 26/2010 via memo dated 14/12/2010 by declaring the dates of Viva, oral test and the place of interview. It is found that the place of interview was at the conference hall of so-and-so Reserve Bank. Call letters are issued by the post. Now I'll pause for a moment. At para 6, my lord, written test was not held by all this person, which you are before this court. Neither the director, who is the petitioner, written test was held by Mtron group. So I don't have anything to do with written test. Written test was taken up by Mtron. Mtron has seen everything was done under the guidance of Mtron. The marks were sent to me, but that's all, my lord. They have made some allegations of written test is concerned. Now kindly see 7. During inquiry, it is found that minutes of meetings with signature of chairman, member secretary of selection committee declared the result on the basis of mark obtained a written test and viva, and the following candidates were selected for the post of assistant tourist information officer. So these are selection committee also were there, but I have been told that they are not been made any party, not an except me and Nobojyoti Bora, deed and deputy director. Kindly, if you see at page 24, these are 2% official capacity. One is Mona Lisa Goswami, which I am representing at page 24. Roman 1 at page 24.
Right.
And Roman 2 is Nobojyoti Bora, deed. Other members, selection committee, they
have not.
Dimbeshwar Deepak was not made a party in this case. I'll come to that, my lord. Now, these are the candidates which has been selected. If you see at page 22 at para 8, my lord, during inquiry, it is found that a writ petition by case number 2408 of 2012 was filed by one C. Raju Kutum, son of so and so, including the selected candidates. However, as per the order of the Honorable Guwahati High Court dated 12/9/2023, petition dismissed on withdrawal by petitioner Raju Kutum. So I think some has challenged the select list, and ultimately it was withdrawn. Now this is important. 9 is very important. 9, 10, 11. During inquiry, it is found that the marks were manipulated against most of the candidates without any signature in the mark sheet of viva of candidates. On scrutiny of the answer script of written test of the qualified candidate selected for the post of Assistant Tourist Information Officer, it is found that overwriting was made with multiple coloring while writing some answer script in the some answers in the answer script of written test of the selected candidate bearing roll number so and so and roll number so and so. However, there was no signature of invigilator on extra sheet in the answer script of written test of the selected candidate bearing roll number of Gautam Gogoi. So this paragraph 9, allegation of written test, was, your lordship can verify and confirm the public prosecutor whether written test, I was a part of written test. It is my submission, written test was held by Mtron, which your lordship, I'll give a quick answer to it. If you see at para 25, page 25, see page 25. See that the minutes of the meeting at C at A. As per submitted by Mtron, the meeting discussed as per result. Kindly see, as per result submitted by Mtron, meeting discussed and decided that cutoff mark of general OBC 70 and for STP and SC will be 65. So these are the results which has been sent by the Mtron. So I don't have anything to say about the written test where they said there is a manipulation, some answer script. So I have nothing to see with the answer script because your lordship knows that Viva, only the marks are being sent. They doesn't send the answer script. Otherwise biasness will come if you see the answer script. Now if you see paragraph 10, my lord, it is to mention that on scrutiny of the files, page para 10. Yes, para 10, my lord, page 22. It is to be mentioned here that on scrutiny of the files related to appointment of Assistant Tourist Information Officer 2010, provided by Director of Tourism, no merit list was found to be prepared by Chairman and Member Secretary of the Selection Committee for selection of the candidates. So on our case is that we have prepared the merit list. It's not a case we have not prepared the merit list. Now 11th, however, during inquiry, the answer script and Viva mark sheet of the candidates scrutinized who were declared qualified call for Viva according a merit list is prepared as per the marks obtained by the candidates. For the sake of substantiating the inquiry and found that the candidates appointed by directorate were not selected on the basis of mark obtained a written test Viva during inquiry. On analyzing our merit list of candidates and selected list by Director of Tourism, the following has been found. That is select list published by Director of Tourism Assam. This is what they found, my lord. If a lordship turn to page 23, table 2, list of candidates who should have been appointed as per our merit list based upon addition of the actual mark obtained in written and Viva. I'll tell your lordship one thing. While the inquiry was conducted, inquiry was behind the back. No notice was given to us also. If an inquiry is conducted, my lord, there a notice should have been given to us. This is what we found. Ultimate, my lord, after verifying it,
What do you
then
have to say?
yes, then they can lodge an FIR. Absolutely no problem, my lord. Like you're putting a cart before a horse, my lord. You do inquiry of yourself. Don't give any, my lord, opportunity, and you decide. Basis on this, FIR has been lodged. Now they said table 2. Now table 3. Observation of inquiry officer in regard to deprived candidate after comparing the above two tables as follows. So they found on an inquiry. Now kindly see in 13. From the above table, it infers that the 8 number of post to rank of Assam Tourism Information Officer cutoff marks for general category should have been so and so, while I% belonging to OBC obtained so and so migrated. As for reserve category, cutoff mark is found, and for ST category, the cutoff is so and so. Whereas for OB category, OBC category, so and out of the deserving candidate, Shri Hiran Saikya of general category, Madhav Das of ST category were rightfully chosen, whereas the rest are undeserving candidate for this post. Based on the facts that emanated in the inquiry, a disturbing instance of alleged corruption in the recruitment to the post of Assistant Tourist Information Officer under Director of Tourism Assam in 2011 has been revealed. 6 deserving candidates reportedly denied the rightful position due to criminal conspiracy involving officials who abused their official power in lieu of illegal gratification. Well, there has to be some type of shown that there is a gratification. On an assumption, inquiry based behind our back. On the basis of, now Lordship, I'll just stress this. On the basis of overwhelming documentary evidence, I would request to register a criminal case against the following government servant. Others are relevant section of law. So these are the documentary evidence, overwhelming documentary evidence. They said this, they have to register criminal case. All the documentary evidence are before them. So there is nothing to interpolate those documentary evidence. Now, on the basis of this matter, the case was registered. Case has been registered, and if your lordship looks at page 25, now only deputy director, my lord will kindly see at page 25.
Yes.
Now, if your lordship looks into, there are 3 signatures your lordship has filed. Deputy Director Tourism, Under Secretary, Director of Tourism. Now, I'll tell your lordship that when an interim bail was granted by this court, I have a date where 4 times I have been called. 4 times. 2/7/2025, 8/7/2025, 18/7/2025, 28/7/2025. My statement is recorded. Number 2, my lord, the manipulation, so far oral test is concerned, they showed, this is my instruction from my client, my lord. I am saying all my instruction of my client. This has been shown, and it appears there is no overwriting. Neither some overwriting. That too, I said that is not my signature, that is the signature of the deputy director. Initial was shown that It resembles at page 25. Your lordship, please note down. It resembles with page 25, the initials of deputy director. They showed me. I said that is not my initial, that's the initial of deputy director, which resembles with at page 25. So, my lord, these are 4 grounds. One is paragraph 1 is a political motivated. 2010-11, 2025, you lost this FIR. Secondly, my lord, enquiry was conducted without giving any notice to me. Your presumption, assumption is based on some chart you have prepared and you have brought by an FIR. At least a chance would have been given to me. I would have given a reply. Thereafter, if you found anything against me, then you can lodge an FIR. Absolutely no problem, my lord. This was not given. All an expertise inquiry was done. 3, my lord, written test was not conducted by us. It is by through an Aptron. It is at page 25. And my lord, lastly, when I was interrogated, we pointed out this is not my initial. Overwriting in Viva, it is initial of the deputy director. This is one. Fourth, my lord, on medical ground, my lord, my husband is suffering from cancer. And I have one daughter who doesn't stay, is in abroad. So all the treatment has to be looked by me, my lord. That's the only problem. And my lord, medical grounds from page 26 I have given. Medical grounds. Page 26 to 34, no? 34. What are they? Medical cancer too? No.
I think.
Yes. So, yes, my lord, your lordship will look into it.
This is different.
Yes, your lordship got it.
Surgery.
Yes. Page 26. CA prostate, your lordship, cancer. Oncology taken for CA prostate. And my lord, reason for admission, your lordship go down below. Set of altered so and so. Patient admitted to so and so and was intubated at so and so following G and connected on so and so. Oncology consultation was taken for so and so. Patient was then put on MB for so and so. Patient was put on TP on so extubated and put on so and so. So and so. Last week also I have been told he has to be admitted. Now we are in a process of taking him in outside. We don't know how it will be done. We don't know. So, my lord, there are some interim order which I have told my lord. Some protection has been given. And all this, my lord, this is more than 11 years, my lord. Custody, my lord, documentary evidence has been already been seized by them. It is all done. Or my whole issue is that whether my custody interrogation is required at this stage or not. Custody interrogation. And my lord, I have been called 4 times. Today also. Yes. What they will do, put me in custody, my lord. How they will, what my documentary evidence, everything is there. I think when you all will get his respect, my lord, this thing were not brought to the notice of the court, maybe, my lord. That's why today I am bringing notice to the court, my lord. And one judgment of the Supreme Court, I think normally a bail we don't show any judgment, but I think I should show one judgment, maybe is connected with a writ petition which went to Supreme Court, my lord. Which went to Supreme Court.
I'll keep it here.
Paragraph key. Please see para 18. See para 18, my lord. After, look, see para 18, my lord. It is after going to the report and the finding, para 18. After going through the report and finding recorded by Division Bench of High Court, we are of the opinion, in fact, the Division Bench correctly assessed the situation. The respondent alone was made a scapegoat, whereas the decision by all the 3 committees was unanimous decision by all these members participating in negotiation, and the price was finalized accordingly. It is not the respondent alone who can be held responsible when the decision is taken by the committee. If the decision of the committee stinks, it cannot be said the respondent alone stinks. It will be arbitrary. If all fish stink, to pick one and say only it stink is unfair in a matter of unanimous decision of the committee. This is what I just want to project it. But there were other also, they have not been picked up. Only she has been made a scapegoat, man. And I retired from my service, my lord, in the year 2022, I think, 22. So that is my humble submission for this one. Thank you. Can I take your lordship leave, my lord?
Your lordship may kindly take up item 31, your lordship.
Numbers.
Item 31, your lordship, Nayan Mani Pamegam. Para 9, your lordship, has already gone through, your lordship, entire.
Yes.
Para 9, your lordship. And then, your lordship, so far as my allegation against me is concerned, your lordship, is that your lordship will, may I read para 9 onwards? During inquiry, it is found that marks were manipulated against most of the candidates without any signature in the mark sheet of viva voce candidates. On scrutiny of the answer scripts of the written test of the qualified candidates selected for the post of Assistant Tourist Information Officer, it is found that overwriting is made with multiple colored ink while writing some answers in the answer script of written test of the selected candidate bearing roll number so and so and so and so. Both these candidates were granted absolute bail by this honorable court, your lordship. Moreover, there was no signature of invigilator on the extra sheets in the answer script of written test of the selected candidate bearing number so and so Gautam Gogoi. That is, your lordship, his bail is pending. Now, your lordship will kindly come to para 12, your lordship. During inquiry on analyzing our merit list of candidates and selected list by the Directorate of Tourism Assam, the following has been found. 1, 2, 3, 4. Your lordship will kindly come to serial number 7. That is Miss Nayan Mani Pamegam, ST. Marks obtained 93.75, your lordship. And serial number in our prepared merit list is so and so. Then list of candidates, your lordship, who should have been appointed as per merit list. Table number 2, serial number 7. According to them, your lordship, Dhirojit Hakmosa, ST, your lordship, he should have been selected against my post, your lordship. Your lordship got it. Yes. Dhirojit Hakmosa, and table 3 is more specific. Your lordship will kindly come to serial number 7.
Comparative skill.
Comparative set. That your lordship, Dhirojit Hakmosa, ST, should have been selected, your lordship. Now, your lordship, here, your lordship, they have not done their homework properly, your lordship. Now, I belong to, your lordship, missing community, which is ST Plains, your lordship. Now, Dhirojit Hakmosa, your lordship, belong to ST Hills, your lordship. Now, your lordship will kindly come to the advertisement. Your lordship will find at page 23. Page 23, your lordship.
Page 23.
That is the advertisement, your lordship, pursuant to which selection was made. Lordship. First page, your lordship, is your lordship the advertisement, and the post and the reservation, your lordship, will get in the next page, your lordship.
Yes.
Assistant Tourist Information Officer, 8 posts are reserved as follows, unreserved 5 number, STP1, your lordship. Now, your lordship will kindly come to page 31. This is a selection, your lordship, by the Panchayat and Rural Development Department.
31.
Page 31, your lordship. Serial number 249, your lordship. 1, 2, 3, 4, 5. 6th from the bottom, your lordship.
Hirojit,
Hirojit, your lordship will last line, your lordship column,
ST Hill.
ST Hills, your lordship. Your lordship, he belongs to different category and Hirojit, your lordship has applied your lordship as a general candidate in that. So your lordship, the fact that in their, your lordship, zest to your lordship, lost the FIR, your lordship, they have, your lordship, made a statement equating both ST Plains and ST Hills as only, that is why, your lordship, they have not differentiated whether I belong to STP or STH, your lordship. That has not been there. And in fact, your lordship, we have also, your lordship, annexed the certificate of Dhirojit Hakmosa, which clearly shows he belongs to Dimasa, therefore he is, your lordship, STH, your lordship. Now, therefore, the very premises on which, your lordship, I was made and accused in this particular case is wrong, your lordship. In spite of that fact, your lordship, your lordship, on the basis of the interim order granted by this honorable court, I have appeared before the investigating agency, your lordship, and my statement has been recorded, your lordship. And secondly, your lordship will kindly see that apart from that, your lordship, there is no allegation, at least in the FIR, against me. At the end of the day, your lordship will see that since 2011, we have got promotion, your lordship. Authorities have, your lordship, never raised anything against us, your lordship. And then, your lordship, after more than 14 years, your lordship, and apart from that, your lordship,
Service.
lordship,
14 years of service.
14 years of service. And your lordship, our selection has been put to challenge before this honorable court, your lordship.
And it was withdrawn.
Yes, that is withdrawn, your lordship. That is withdrawn by one Raju Kutum, your lordship. And in that case, all of these, your lordship, candidates were made parties. They are also, your lordship, authorities have not raised anything against it. Not, there was no affidavit in opposition, your lordship, alleging that there is some kind of manipulation is there, your lordship. And your lordship has seen, your lordship, that this is purely on presumption they have made, your lordship, in para 14, that this has been done, your lordship, in lieu of illegal gratification, your lordship. Except a bold statement, your lordship, general statement, at least in the FIR, there is no material to show that money has changed hands, your lordship. And based on this kind of FIR, your lordship, these people are, your lordship, now put to, your lordship, test, your lordship. And therefore, your lordship, already, your lordship, the documents has been seized, your lordship, everything is there, investigation is going on, your lordship. We have cooperated, your lordship. Probably at this stage, custodial interrogation is not at all required. And therefore, your lordship, my humble prayer, your lordship, before this honorable court is that, your lordship, this petitioner may be, your lordship, granted the privilege of pre-arrest bail, lordship. We will be ready to cooperate and we will go on cooperating, your lordship. And your lordship will kindly note, your lordship, till date, the departmental authority has not initiated any action against us, your lordship. Departmental proceeding, etc. Nothing, your lordship. This is an purely, your lordship, we don't know who is in there, your lordship, aim, your lordship. And then, your lordship, item number 30, your lordship.
Same, you all appearing in that also.
Otherwise, same, your lordship, only in para 9, your lordship will kindly come to. There is an allegation against me, para 9 of the FIR.
He's Gautam Gogoi.
Gautam Gogoi, your lordship. Moreover, there was no signature of invigilator on the extra sheet in the answer script of written test of selected candidates bearing roll number so and so, Gautam Gogoi, your lordship. Now, only for that, your lordship. Now, whether your lordship invigilator ought to have, your lordship, is lordship.
Anyway.
Lordship. That is the allegation, and that I should not have got. And your lordship will kindly see, I belong to OBC, your lordship. They have shown me as a general category candidate, your lordship. Table 3, your lordship.
At page?
Page 18, your lordship.
General category.
General category, and the person, your lordship, who is deprived is shown as an OBC, your lordship. Now they are hell-bent on lodging an FIR, your lordship. Therefore, they have lost it, your lordship. While doing so, your lordship, they have committed this, your lordship. And ultimately, your lordship will kindly see, it is not the only case where I don't know, your lordship. There may be something, your lordship, that persons who should have been selected, not selected, your lordship. The other, your lordship, candidates, normally we have seen, your lordship, that there are lots of cases, writ petitions are filed, your lordship, challenging the, your lordship, selection of the different persons, your lordship. Can, in every case, it can be presumed that since the person concerned who should be appointed was not appointed, there is a change of money, your lordship, and illegal
There should
gratification?
be some objective basis
Lordship,
for
there
saying
must
that.
objective
There
basis
has to be
should be
some
there, your
objective
lordship.
basis, obviously, and to say that candidates have not been selected.
Lordship,
Not subjectively,
lordship,
but objectively.
lordship. Therefore, your lordship, in my
That
humble
so and so
sub-
was a better candidate,
Lordship.
not in that sense.
Lordship,
In an objective sense.
lordship,
I have got this much marks, which is more than you,
Lord.
so I should be. able.
lordship.
That's
There,
something like-
there are cases, your lordship. Not every case is not, your lordship, that illegal gratification has taken place, your lordship. At the
Yes,
end of the day, your lordship, we are cooperating and we will cooperate, your lordship. Custodial interrogation is not required, your lordship. This is my humble submission.
May I please, Your Lordship, appearing in item
Yes.
number 30.
Just a minute. Yeah.
Item 33, Lordship. His petitioner's name is Panjal Bora, and he was appointed on 21/2/11 as Assistant Tourist Development Officer, Lordship, and thereafter he was promoted. And so far, para 9 is concerned of the FIR, there is no allegation against him. So against 3 candidates, there are allegations that there was no sign in the
Actually,
extra sheet.
any significant delay in starting any kind of investigation
Lot.
creates lot of complications.
Lot of complications.
Complications for both sides.
Both sides.
So anyway, the sooner
Yeah,
the
there is
better.
no- yeah,
Sooner
there-
the better, if at all. If at
Lot.
all investigation has to be done, the sooner the better. Anyway,
Lot.
so
In para 9, there is no allegation against me in the FIR. Only against 3 candidates allegations were made. Out of those, already interim bail was made absolute so far. Simon Mannan and Mahjubin Begum is concerned by this honorable court. And so for table 3, I'll also will kindly go through page
Page?
21. Page 21, table 3. Comparison with the deprived candidate. My name appears in serial number 2. Pranjal Bora, general, marks 134.75. And interestingly, there's comparison with nobody. Only 139.75 marks is there. Name is not there, roll number is not there. And so for 139.75, Hiranya Kumar Sakya, he's already selected. The serial number 1, Hiranya Kumar Sakya, also will kindly see. Marks obtained is 139.75. He has already been selected. And my comparison is made with Neil.
Neil.
With Neil. And the marks is of that of Hiranya Kumar Sakya.
same as. Hiranya.
Same. He is already selected. And there is no grievance against him also.
The Mr. Das, London Senior Counsel submitted regarding Gothakur, some candidate whose bail was rejected by this court.
Ananya Bhatt.
Has he gone to? the-
Mostly by your lordship.
Okay, has he gone to Apex Court?
Or that we are not.
Yes, sir.
He
Yes, sir.
He has not filed second application also.
Second application also he has not filed. But after getting the interim, he has appeared before the, I will also say most of the statement has already been recorded. And now he is presently posted at Nagaon, and he has also been promoted. And we are ready to cooperate, and we have been cooperating since after lodging of the FIR lordship. So my humble submission is that as the whole case rests upon documented evidence and documents having been seized, and I already cooperated with the investigation of the case. So with conditions, I'll also will make the interim bail absent first. And that too after 14 years of the incident lawsuit kind of. That is the vital
problem.
point.
That is the point.
And whether my custodial detention is required at this
It's
stage.
lot of difficulties.
That you'll also will consider. That is my humble submission.
Prosecution submission will be combined, of course.
Yes, madam. Now, first of all, I am coming to see Mona Lisa Goswami, madam.
Just a minute, Mr. Kotak. Get over to me. इधर ऐसा. No. Yes.
As submitted by my learned senior counsel, my lord. First submission was that before lodging of the FIR, there was a preliminary inquiry. And during the course of preliminary inquiry, my lord, no summon was issued there, they never participated. So they want to point out that there was a violation of principle of natural justice. Now, your lords will find, so far as the BNSS subsection 3 size, my lord, 173, my lord.
Just a minute, I'm coming to you. UNSS section.
Section 175(3), my lord. BNSS. Without prejudice to the provisions of section 175, on receipt of information relating to a commission of any cognizable offence, which is made punishable for 3 years or more, less than 7 years, the officer in charge of police station, which may with a prior permission of the officer not below the rank of DSP, considering the nature and gravity of the offence, proceed to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days, or proceed with investigation where there exists a prima facie case. So when a complaint has come, my lord, some allegations are made. Naturally, before lodging of the FIR, they have to verify, my lord, whether any inquiry has to be conducted, my lord. For that part was in such preliminary inquiry, my lord, participation of the accused is not necessary. They have to only verify the facts. What actually has taken place, my lord, to ascertain the fact, my lord.
In this case, preliminary inquiry.
Yes, inquiry was conducted, my lord. There subsequently FIR was lodged.
Preliminary inquiry, that inquiry was a departmental inquiry.
Not the departmental inquiry. Inquiry conducted by the
Police.
police, my lord.
And thereafter they proceeded to.
Yes, my lord. Considering the nature of the case. Now, second submission before lodged, my lord. It was made, my lord. That she was, according to the senior counsel, she being the one of the members of the selection committee, she headed the selection committee. She was not responsible for the exams that was conducted prior to the selection, my lord. According to them, my lord, it was conducted by Mtron, my lord. And Mtron conducted the exams on the basis of marks which were given by the said mark sheets, my lord. The selections were made. That is the basic summation. So they relied upon the marks that has been obtained in the
From Mtron.
Mtron, my lord. Now, during the course of investigation, what has come light, my lord? Now, if your lordship, that I'm giving my objection also, but that's I like to point out, my lord. That she was actually the main culprit, my lord, in this case, my lord. What has happened? Whatever mark that has drawn from the, because there are 4 officers were there in the selection committee. Only 2 participated.
4 officers.
4 of which are there, well, 2 participated. The 4 officers are namely. In the FIR, you all of them. Para 3 of the FIR, you'll also find.
I'll come to that just a minute. Para 3.
Para 3, my lord. Mona Lisa Goswami, she is the director of tourism, she was chairman of the commission. Dimbesa Soika, Under Secretary, Department of Tourism. Deepak Majumdar, Deputy Secretary, Personnel Administration, and Namojoti Bora, Deputy Director of Tourism Headquarters member. These are the 4 persons, madam. Page 20, madam. But Mona Lisa being the chairman was presiding the committee, madam. But so far the selection is concerned, there was no resolution, no minutes were maintained, madam.
Who did not participate?
Dimbesa Soika and Deepak Majumdar.
They did not participate.
They did not participate. No signature was. And first of all, my lord, no procedure was maintained regarding the selection of the candidates, my lord. There was no minutes, my lord, of the selection, my lord. On what basis selection was made? Now, further during the course of investigation, it has come to light. While examining Dimbesa Soika, my lord, he was Under Secretary of Department of Tourism, my lord. He has categorically had stated, my lord, the mark sheets of the candidates who were selected, my lord, they were manipulated, my lord.
Page 315 of the case diary.
It was available in page
315.
315 of the case diary, my lord. There was mark. Because these mark sheets were sent to the expert committee headed by a Guwahati University professor. They examined the mark sheet, my lord, and they were found that there were many manipulations, my lord. The colors were issued, different colors were issued, my lord, and overwritings were there, my lord. And subsequently, this and your lordship may kindly this Navajyotis Bora statement, your lordship may kindly find at page 252, my lord, of the case diary, my lord. Your lordship may kindly note down there, your lordship will find.
Of the case diary.
Case diary, my lord.
It's 252.
252, my lord.
Important.
And there is a page 1.75 is a statement of Mona Lisa Goswami. She remained silent, my lord. She did not cooperate. She did not answer to any of the questions, my lord. Page 232, my lord. There is a statement of the expert committee, my lord. Then you will also find. Then at page 257, here there is a statement of one Madhurya Bora, my lord, saying about in the evaluation sheets, there is no signature of the invigilator, my lord.
At page?
Page 257, my lord.
Madhurya Bora.
Madhurya Bora. No signature of evaluations of answer scripts. They were overwriting in the answer scripts, my lord. And yes. And 261 is the statement of another professor, Mr. Bhaven Tati, my lord. Okay, it's expert committee to I use. Candidates. And page 235 and 236 is a regarding the flaw of procedure, my lord, regarding selection of candidates, my lord, where undeserved candidates were selected and deserving candidates were not selected, my lord. Oh, well. Then therefore, this expert committee again, after reviewing these said irregularities, my lord, they prepared a merit list, my lord. As far as the actual marks ought to have been secured. That merit list was prepared at the page 271. Then page 315, my lord. There's a statement of one Durgeswar Soikia, my lord.
Member secretary.
Member secretary, my lord.
315.
215.
315.
315.
Durgeswar
Soikia. Dimbesa Soikia. He was the under secretary, member secretary of that part. He says that marks were received by the MD without any signature from the emperor. And no signature, evaluation and marks were given by pencil.
So that it can be page number 31.
Page 318, 319, my lord. This statement is there, my lord.
Using a pencil.
And he also stated about and there was increase of rounds of these candidates, my lord.
Page 321.
321, my lord. These candidates, Pranjal Bora, Omilo Borthakur, Ananya Borthakur, Sayamin Manson, Meherzabin Begum.
writing by Mona Lisa, it's a direct statement.
And there is a direct statement, in the mark sheet also, there is a overwritings made by this Mona Lisa, my lord. Being the chairman of the committee, my lord.
This is with reference to any page number? Is that-
321, ma'am. There is a statement of the,
Oh, this is not written. Number three.
so your lordship, while that the selected candidates, my lord, ought not to have been selected. Initially in the mark, in the, this answer script itself, their marks were manipulated. I'm coming to the serially one, my lord. So far as the petitioner, your lordship, that's Mr. Bortako appears on behalf of Noyanmani Pangam, no? Noyanmani Pangam, my lord. In written, his roll number was 0380, my lord.
Zero three eight zero.
80, my lord. In written test, my lord, he obtained total marks of 65. Question number 2, my lord, marks given to question was corrected without any initial, my lord. And in an oral test also, my lord, 21 marks were added and without any signature, my lord. As a result, he secured 115 marks, my lord. In a merit list, her position was supposed to found to be 256, as she scored only 93.75. But in the ST plain category. But there were 9 numbers of candidates who secured higher than him, but they were not selected.
Regarding that contention, that the category was mixed up by the authority.
Because, I understand, my lord, but we don't know what is the Indian advantage, whether it was meant for, it was reserved category, whether it was meant for hill tribes or scheduled tribe hills or that, but there was manipulation in the marks. That is, otherwise you would not have been selected, my lord. And in next month, they have given the name of the persons who have ST categories who have been deprived. Similarly, in case of Pranjal Bora, my lord, his roll number is 0360, my lord. Now, what happened in this case, my lord, his marks regarding 40 marks were increased to 44, my lord. In the
From 40
to 44, my lord.
44.
As a result, it was signed by one of the members of the committee, my lord. That is Navajyoti Bora.
Why it was increased?
Without any justification. And in entire merit list, my lord, his position was at 6 in the general category. But there were 4 candidates who got secured higher marks than him, but they were not selected. Gautam Gogoi. Gautam Gogoi, he actually, his roll number is 541, my lord. No, not 541. 1001. No? But his overall position in the merit list is 47. Securing a total mark of 116.75.
Okay. There are candidates securing more marks than him.
Yes, my lord.
Who are not selected.
Not selected.
In the same category.
Same category. So, so I'm placing the CD as well, my objection, my lord. Your lordship. Now, there are Supreme Court decisions my lord, that has been relied by my senior friend. There's a matter relating to a tender matter. Tender matter which was where some unsuccessful tender was illegally, but there's not matter related to manipulation of marks. And since it is a matter of public employment, undeserving candidates were selected. The procedure established by law has been violated to the large extent. In fact, there are decisions of Supreme Court on this point.
Investigation definitely should do it properly, but the prosecution also has objection to, the prosecution thinks that their custodial.
Even them
may be
custodial,
necessary
because the Supreme Court says.
at this stage, so.
Yes. It is not necessary that custodial case that. Your lordship may kindly take up 2022-17 SEC matter. 17 page 391 matter. Paragraph 12 matter. Regarding custodial interrogation part, my lord, that has been stated.
Paragraph 12.
12 matter. Your lordship will find paragraph 12 says that we are dealing with a matter.
Yeah, go ahead.
Paragraph 12. We are dealing with a matter where original complainant appellant has come before the High Court praying that anticipatory bail granted by the High Court to the accused should be cancelled. To put it in other words, the complaint says the High Court wrongly exercised the discretion while granting anticipatory bail accused in a very serious matter like POSCO. Therefore, order of passed by the High Court granting anticipatory bail to the accused should be quashed. In many anticipatory bail matters, we have noticed one common argument has been canvassed: no custodial interrogation is required. Therefore, anticipatory bail may be granted. There appears to be serious misconception of law that if no case of custodial interrogation is made out by the prosecution, and then alone would be a good ground to grant anticipatory bail. Custodial interrogation can be only one of the relevant aspects to be considered.
This is the thing. I've gone through this because it
Along with the other grounds.
gives
Right?
you the benefits of the general bail order also.
Yes, sir.
It is a general bail order also plus something.
So there may be many cases which custodial interrogation may not be required. But that doesn't mean that prima facie case against those should be ignored or overlooked. And he should be granted anticipatory bail. First and foremost thing that a court being anticipatory bail application, hearing application, should consider is prima facie case put up against the accused. Thereafter, the nature of the offense should be looked into, along with the severity of the punishment. Custodial interrogation can be one of the grounds to decline anticipatory bail. However, even if custodial interrogation is not required or necessary by itself, cannot be a ground for anticipatory bail. So, and in recently, my lord, that is in 2025 4 SEC, my lord, in case of Bansal, my lord, where parameters of anticipatory bail has been laid down.
Reiterated.
That is 2025 4 SSC 493, man. Devinder Kumar Bansal versus State of Punjab, man.
Page number?
Page, your lordship, paragraph 21, page 501.
Okay.
Para 21. Para 21 says that parameters of grant of anticipatory bail in serious offense like corruption are required to be satisfied. Anticipatory bail can be granted only in exceptional circumstances, where court is prima facie view that applicant has been falsely enwrapped in a crime of allegation of are politically motivated or frivolous. So what a case in hand, it cannot be said that exceptional circumstances has been made out by the petitioner for grant of anticipatory bail. Therefore, there is no frivolity in the prosecutions. That now in paragraph 23, my lord, the presumption of innocence by itself cannot be the sole ground for anticipatory bail. Presumption of innocence in case of consideration which court should keep in mind while considering the celebrity principle to balance the cause of the accused and balance of public justice. Over solicitous homage to the accused's liberty can sometimes defeat the cause of public justice. If the liberty is to be denied to an accused to ensure corrupt-free society, the court should not hesitate in denying such liberty. Where overwhelming consideration in a necessary aforesaid required, denial of anticipatory bail, it has to be denied. It is altogether a different thing to say that once investigation is over, such is submitted, court may consider regular bail to a public servant accused of indulging in corruption. So, in corruption cases, Supreme Court, from time again, my lord, saying that anticipatory bail should not be granted. Because it is public confidence loses, my lord. And here there's a serious allegation where manipulation of marks are there by the chairman. Man. Without any merit, the undeserved candidates were selected. Man. So I leave to your lordship.
This will require some study.
Yes,
So I'll reserve it.
Yes.
Kindly.
Only one.
Reply has to be done.
Only one thing.
Reply, we'll,
Item 32 Mona Lisa.
after lunch, you can reserve. What do you say?
Only one thing, your lordship. At page 25, your
You have
lordship.
a right to give reply.
Yes, only one thing, your lordship. My learned senior has submitted that no minutes were prepared during the selection process, and Dimbeshwar Patia and Deepak Majumdar did not participate. So only at page 25, your lordship, may kindly come.
This is the general reply for all the petitions or one specific?
Mona Lisa, item number 32.
Mona Lisa.
Item number 32. AB 1464 of 2025. Page 25, your lordship.
Yes, sir. Yes, I said before me.
Yes. Page 25, your lordship. Only one thing, my learned senior has pointed out that neither any minutes were prepared, and Dimbeshwar Sajja and Deepak Majumdar did not participate in the selection process. This will clarify, your lordship. Page 25, it starts with
I've seen.
minutes of the meeting. So it was prepared. And this pertains to the same selection process, your lordship. And down below, 3 initials, your lordship will find. First one is, as already stated, is Navajyoti Bora, one of the member of the selection committee. The second itself, under secretary, tourism, who happens to be Dimbeshwar Sajja. So he did participate in the selection process, your lordship. So it's a wrong and false statement that he never participated in the selection process. The signatures and initials are there, your lordship.
That's regarding cut-off marks only, man, not regarding selection.
Anyway, he is a part of the selection process. So, and he has participated in the selection process. So this is my humble submission. And also at page 24 in the FIR, they have stated that the entire case was registered only because there was some illegal gratification. But my learned senior has never submitted anything, nor I think that there is anything in the case diary regarding illegal gratification by any of the members of the selection committee.
Ultimately, your lordship, to call it a corruption, your lordship,
Yes.
of involving monetary transaction, there will have to some trail of money changing hand, your lordship. Unless it is not there, your lordship. Even assuming what they have submitted, your lordship is correct, then also your lordship will not automatically can be constituted as your lordship corruption. And your lordship will kindly see, your lordship, that they have constituted a new committee, your lordship. That marking itself is a matter of subjective satisfaction, your lordship. Now, new expert, your lordship, new committee, new examiner, your lordship, they will go on.
No, they cannot re-evaluate the marking.
Yes.
Yes, my lord.
Whether 3 out of 5 is correct or not, that is not, cannot be.
Not
re-
that kind of, but overwritings were there.
Whether 3 has been counted as 3.
Man, overwritings are without signature of the invigilator, nothing.
You're right.
And regarding overriding also, as shown by my learned senior at page 318 of the case diary, it is made by the officials of Amtron.
No, by Mona Lisa.
Amtron in the written test,
Because
we didn't have the access to the answer script of the written test.
And so far as your lordship, Noyan Moni is concerned, your lordship, as I have pointed out, your lordship, the advertisement is very specific. It was for STP, your lordship, the postage is up.
That is one point actually that they have. Anyway.
Deeply obliged.
Obliged.
There is a council, item number 32, the learned senior council, D Das. Item 33, D Talukdar. Bottom Gogoi would appear.
I am.
Bottom.
31, I am.
30 and 31 is Santanu Botak and Special Public Prosecutor, CM Vigilance. Arguments heard. Order is reserved. The case diary we kept with the case report. Okay.
Lordship, I beg indulgence regarding item number 16 and 17. Lordship, can be taken up after 3:30, Lordship. I have a item at the division bench.
Comfortably.
16 and 17.
Don't worry. Oh,
May I please, Lordship?
AB.
CD was called for.
CD
applicant
received, Lordship.
Call for my lord. Petitioners are not increased, my lord. Lordship will find FIR as case 10, my lord. Starts from 9, the relevant is 10. Both the petitioner on entry, my lord.
There is statement available, Lordship. Statement. available.
Statements are recorded.
Lordship.
Is it a case of allegation of theft?
Theft.
You can make your submission. You can make your
Others,
submission.
Lordship, main mastermind, Lordship.
Yes.
One Babul Rava and Saidul Islam, Lordship.
Mhm.
All the Lordship, seizure witnesses, Lordship,
They're implicated.
implicated this two mastermen, Babul Rava and Saidul Islam.
These two persons,
Not implicated.
not implicated. So they were. So I think then yes, make it a absolute. Their statements also recorded.
Yes.
जो आगे order to come only no. First name I guess. The gist of the allegations in the FIR pertains to FIR dated 2/8/25 pertains to theft of sewing machine. And information regarding the same was obtained by villagers who accordingly informed the police station. And thereafter, the police seized the sewing machine. The present two petitioners were granted interim pre-arrest bail on 22/8/2020. The case diary has been received. This thus learned additional PP submits that investigation has revealed incriminating materials against the two main accused. However, the witnesses examined have not implicated the present two petitions. It is further submitted that pursuant to grant of interim, they have also appeared before the IO and their statements recorded. In the given facts and circumstances, the interim bail granted by order dated 22/8 is hereby made absolute, subject to the condition that they shall cooperate with the process of law. Return back the case diary.
Obliged.
Lordship, this is an anticipated bail application.
Let us see the FIR. First, you're seeing only 12 accused persons, named in
Page 11, Lordship.
11 accused persons, 12 accused. Oh, no, more than that.
Or total 15,
No, even more than that.
more than that. You are not named.
24 plus unknown others.
Yes, sir.
Okay. Let's see, what is the allegation?
Now, your Lordship, since the FIR is a little lengthy, I would just like to keep it brief.
Okay.
So as per stated in the paragraph 2 of my petition, that is at page 3, the complainant lodged an FIR before the officer in charge of Buragaon Police Station, stating inter alia that the informant's family and the FIR named accused persons were engaged in a land dispute, and the FIR named accused persons, by way of force, tried to plow their disputed land with the intention to evict them. And when the complainant's elder brother and another individual, with the help of other persons, tried to stop them. They attacked both of them. As a result of the attack, the complainant's elder brother died on the spot, and the other persons was grievously injured. Now, Lordship, here my humble submission is that the petitioner is acquainted with accused number 1, and on the day of the alleged incident, he was while he was on his way to Buragaon, Morigaon, he happened to meet Yasin Ali, who is accused number 1, as per the FIR. So, and on the request of the accused number 1, he gave him a lift on his motorcycle. So that is how he was seen with the accused person. Apart from that, he's nowhere connected in the incident. He doesn't even have knowledge while giving the lift that before that he has committed the offense. So that is my,
Oh, after the incident, he asked for a lift.
yes. It was not in the knowledge of the petitioner what had happened earlier.
So that would be your instruction, right?
Yes.
You are appearing for informant?
Lordship.
I'll come to you.
Lordship.
First, let me.
I'm not sure.
additional-
I have gone through the statement of the Caesar witnesses as other independent witnesses, along with the complainant and victim statement. Lordship. And the postmortem report says, out of the long standing land dispute between the two parties, one person succumbed to his injuries as a result of physical assault, which is done by more than 15-20 persons. It's a kind of mob attack. Okay. So thereafter, one person died and one person sustained injury, previously injured. And so far as the postmortem report of one Lordship Saidul Islam is concerned, the report says the cause of death is due to massive hemorrhage and shock leading to cardiorespiratory failure and as a result of multiple injuries sustained by a person during his life. So that is also.
Any specific, this thing with regard to this person?
So far as the statement of the complainant, Lordship, he has implicated the present petitioners, and from the statement of other witnesses, it reveals that they have identified 4-5 people's name, but all put together 15-20%, 10 to 15 persons has been.
Difficult also, 15-20 persons were there.
It is difficult.
Difficult, and out of them, 4-5 have been identified.
Yes, only 4, 5, 6 has been identified, and.
Not this one.
Lordship?
And for, the GRO log is not amongst those identified 4-5 persons.
Yes, but.
It's not.
But.
Overall, they are implicated.
They're implicated, Lordship. And from the statement of the complainant, he has specifically stated that his involvement is there in the list. Lordship, may kindly go through the statements. Yes. He has been brutally murdered, Lordship, brutally physically assaulted by all the men.
K. Bora. K. Bora.
Miss P. Bora.
P. Bora. Learned counsel for the petitioner.
He's one of the associates.
And SH Bora, learned additional people. Also, yeah, sorry, you make your submission.
Lordship, Lordship, the present petitioner is the accused number 15. Lordship, it is specifically mentioned in the FIR, Lordship. In the middle question, Baki 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 14, and 15. This is the accused present petitioner. 15 আসামি গণে উক্ত ইয়াসিন আলী আৰু ইলিয়াছ হুছেইনৰ লগত সহযোগ কৰি হাতত দা জাঠি লৈ এজাৰকাৰীৰ ককায়েক সাইদুল ইছলামক হত্যা কৰাত সহায় কৰিছিল. So he helped the other accused and executed such a brutal murder.
And
So he is very much involved, Lordship.
His present is very much there at the time of occurrence.
Your good name? Your good name?
N. Hawk, Lordship.
N.
And this honorable court, Lordship, and already rejected the bail, pre-arrest bail prayer of accused number 2, 10, 15, 16, 16, 17, 19, 20, and 21, and 23. The AB numbers are already attached in the record, Lordship, files, Lordship.
Anyway. The as many as 24 persons are named in the FIR dated 18/8/2025, including the present petitioner as accused number 15. The gist of the allegation is that pursuant to a land dispute, the accused persons in a pre-planned manner attacked the informant's elder brother, Saidul Islam. And brutally murdered him, brutally killed him. And in the incident, they also caused serious injuries to another. The learned petitioner counsel submits that as per her instruction. After the incident, the present petitioner, without knowing about the same, might have given a lift on his motorcycle to the accused number 1 on his request, and that he was unaware that prior to that point of time, accused number 1 might have been involved in the incident described in the FIR. Full stop. The learned additional PP submits that apart from being a brutal killing of the victim, the informant in his statement recorded during investigation has reiterated the allegations regarding the present petitioner as well and implicated him. Full stop. As for the investigation, several persons are stated to have been involved in the incident, out of which 4 or 5 could be specifically identified. Mr. Hawk, the learned counsel for the informant, objects to the bail and submits that the involvement that the present petitioner is very much involved in the alleged incident. He also submits copies of orders passed in 3 other bail applications of co-accused, rejecting the prayer for anticipatory bail. The investigation is not yet completed. In the given circumstance, this may not be an appropriate case for anticipatory bail. Accordingly, the same stands rejected. At this stage, return back the case time. Okay?
Highly advised.
Before.
May please, your lordship.
Connected.
Lordship may kindly take up the unlisted matter first. AB number 2519.
Well, in this case, my lord, trial court records are necessary, my lord, because this is a listed matter report recovery of 26 kilos of methamphetamine tablets.
You are appearing for the DR?
DRM, my lord,
Yeah,
and
yeah.
the value of those 26
Your
kilos
good
is
name, please?
MK Boro, my lord.
MK board for the, okay. Commercial quantity, 27 A's of the time. Records are not received.
Lordship, this is for motion,
It's
lordship.
come from motion.
Both, not for the first time.
Only difficulty is that, lordship, next date is fixed on 27th, lordship, and someone has been issued.
My lord, it's a commercial quantity, the AB, my lord, the anticipated bail may not be granted without
In any case,
going
we
to
have to see
TC.
the case diary.
Yes, my lord, because
And,
this is the value of
the
the,
37 will be applicable, right?
yes, my lord.
Unless there is something to, hold, unless there are materials to hold, that 37 would not be applicable.
Yes, yes.
At
lordship.
this stage,
As
right?
because, lordship,
So-
quantities were recovered from the other person, lordship. 2 persons who are already been arrested.
They
lordship.
were arrested at the same time?
No, lordship,
No,
this is
they-
anticipatory.
They were absconders, my lord.
Initially, lordship, learned court below granted us interim bail. Pursuant to that, we appeared. Our statements were recorded.
Subsequently cancelled.
Yes, lordship.
Anyway, একটু লিখে নাও অর্ডারটা একটু না দুজন আছে AB 2519 of 25 482 bail application Khairul Hussain and Altaf Hussain, 2 persons, in connection with NDPS case number 157 of 20, within bracket arising out of DRI case number so and so title number. Actions. Dash Radi, pending before the learned additional session judge number 1, Kamrup Metro at Guwahati. Mr. M. Boro, learned public prosecutor appearing for on behalf of the
My lord, it's called senior standing counsel.
senior standing counsel appearing for
DRI.
the prosecuting agency, the investigating agency DRI. Submits that besides being an anticipatory bid, the adjudication will also necessitate perusing of the case diary. Is this at the stage of investigation?
No, my lord.
My charge sheet is filed.
Charge sheet.
Charge sheet is filed, so we'll need call for the
may be called.
scan copy of the case diary, charge sheet. Depositions, the trial has not started.
No, no, my lord. It is
No,
appearance
it's the
stage.
appearance stage.
Case diary and charge sheet of the learned court below. Constable. So, this is to be fixed. And what about this one? Is it connected?
Same, my lord.
Two different accused.
Yes,
different
lord.
accused.
3 different accused, lordship. In the production list, there are 2 accused person.
Two.
Yes, ma'am.
Similar hotel, AB 2515. Only 2515. Samsul. Maybe, lucky here. So, you mutually work out a date and let me know.
First week of November, lordship.
411,
Kamrup Metro.
10th of November, my lord.
411, 611, 411.
611.
Can you, is it okay?
My lord, that
Sixth.
is my 10th, 11th.
10, 11. Oh,
Highly obliged, my lord.
yeah.
May it please the lord, sir.
My lord, regarding service of notice, my lord, I'm trying to get the instruction, but till now.
You did not receive, lord.
1/9/25, which was called for. Then it was fixed on 23/9/25. Ultimately, it is listed today.
It is from which station?
Korimbganj.
Investigation is going on.
Yes,
Like,
it is going on.
Commercial quantity, so we have to see 37.
One day was short date if CD is already 1/9/25 CD was called.
So should have come by now. The case diary of Korimbganj case number 282 of 25 was called for, but the same is not yet received. Issue reminder for the same. The case diary may be procured positively the next date. The accused is in detention since 12/6/2025. Okay, you try to get it.
Fix all?
30 law. 30. Fix it on the Monday. 30 might be a little tight because of some reasons. 311, lodge. Is it okay? 311.
311.
Lodge.
If they can bring out 30, might have let it be on
30 will be a little difficult. Lodge, 311.
311.
311, lodge. Yeah.
May I please to Lordship? Well, in this case, my submission, my lord, for the same cause of action, my lord, the earlier FIR was lost. And which was investigated, charge sheet was late.
Again, this is fine.
Again, my lord, for the same cause of action, the mother of the victim filed a complaint. On the basis of that, my lord, police filed final report, saying that the case was earlier investigated. Subsequently, my lord, the objection petition filed on FR, my lord,
It was
and
a
the investigation
complaint
order,
case.
and again CS was filed, my lord. And my lord, on observing the statement of the victim under 161 and 164, it is clearly, my lord, we can presume that it is connected with the earlier FIR, my lord.
not connected with the subsequent FIR. So
There
I-
has been,
Lordship, in this case, Lordship charge sheeted and moreover,
let me see the order. Submitted. Fine, they were given interim bail on primary basis satisfaction that there is no compliance. Okay,
Yes,
now we have the case diary. It's
Lordship,
come, right?
Scan copy of 47 and 47, 48 notice was called for, which has not been
I
received.
think we call for, didn't we call for the entire case diary? Let me see.
Point number 5 of
Just a minute.
the last order.
Project, this is- Okay, okay. Scan copy of case diary and charge sheet.
Yes,
It
Lord.
has come?
No, it has not come, Lord.
It's not come.
Lordship, regarding the notices 47, where I have the certified copies, Lordship, including the final complaint. Lordship.
Yes, since you are already on interim, it's
Yes.
better to have a look in. Certified, let me see.
Yes.
So, prosecution, it will be for satisfaction of prosecution also, this is necessary. So you check with the original records, the scan copy has to be procured on the court,
Lordship, from the
Right.
court, Lordship.
from the court. But I can have a look, you submit. Since it is commercial, otherwise there are a lot of rigors of 37 will apply otherwise. But because it's a procedural infirmity, that is why this has been given. But nevertheless,
I have recognized, Lordship.
since already interim has been given.
Yes, Lordship.
There's no problem.
Even in the 47 notice, they have stated nothing.
That is why prima facie
Yeah, Lordship.
notice you have annexed must be the one.
Yeah,
No, I'm not
Nothing has been
Disputing
stated,
or
Lordship.
doubting or
been
disputing
recovered,
this.
what has been recovered or not, Lordship, nothing has been. It is a simple three lines, one line notice, Lordship. Simply stated that you are hereby arrested. You may submit petition before the honorable court for bail. This is the notice. The certified copies, Lordship.
There are two persons here, right?
Lordship,
Two persons.
one
Two
Mohammed
staff.
Nur Safi and Sharif Sasan.
Is there, you can have a look if you want. Have a look. Did you want, take it up. You also have a look. If you think we can dispose it of, otherwise we'll extend the interim and call for the record. Otherwise, this is a certified copy, but it's true.
But on this ground, notice 47, 48 Lordship, earlier my senior already submitted on this
That's
ground,
true.
Lordship, and some judgment relied, Lordship. The same submission should be recorded. They have annexed the judgment, Lordship.
That darshan, actually there's now another judgment of Supreme Court, Ladakh, and very recent, where this thing has been said that where there is conflict between two benches. The earlier in point of time has to be followed. So anyway, this is still emerging.
My prayers to Lordship may make absolute Lordship.
You want me to call the scan copy?
No, which may not be necessary because it's certified copy.
That is
Lordship.
true. Yes. If the prosecution insists, then I will call. Otherwise, we can dispose it of. There's not in dispute. ঠিক আছে, আগৰ অৰ্ডাৰটোৰ পৰা আমাৰ হৈ যাব, ফাৰ্ষ্ট paragraph, second paragraph, third paragraph. Those scan case record has been, was was called for, but the same is not received. In this context, the learned counsel for the petitioner submits before the court certified copies of the notices under notice under section 47. 48 notices also here?
Yes, Lordship.
Of the 47, 48 notices. Yes. Perusal of which reveals that the same notice which is annexed with the bail petition, and on the basis of which, upon being satisfied prima facie about non-compliance, this court had granted interim bail to both the accused persons by the order dated 26/9/2025. What was the page number? Can you help me with the page number again? Or your 60 mark, please. This is the 47 notice, no Safi and this thing. I perused once again the certified copy of notice under 47 BNS issued to accused Noor Safi and to Sharif Sesam. Both the notices are identical and may be reproduced herein below. এখন থাকলে হবে। এখন থাকলে। The aforesaid notice undoubtedly fails to meet the stipulations laid down in the case of Bihan Kumar versus State of Haryana, Kasai citation 2. Then, in terms of the settled law now governing the field, entitles the accused persons to be granted bail. And this should be so, despite the applicability of the rigors of section 37 in the instant case. Accordingly, the interim bail granted to the accused by the order dated 26/9/2025 is hereby made absolute. And subject to the conditions that, same conditions, same condition. Sorry, I don't, the learned, the learned standing counsel.
No, counsel for the NCB Lordship.
NCB, standing counsel for the NCB.
Lordship, I'm appearing on behalf of SC.
That I know. MDECA, learned counsel appearing for the standing counsel NCB. Objects to the grants of bail and submits that in terms of the law laid down in the case of state of Karnataka versus Darshan, ... No prejudice, any such non-compliance or inadequate compliance may be subjected to a prejudice test. And in this context submits that the accused persons were made aware about the reasons and grounds for their arrest. Full stop. Can I keep it for, she will just need it to reproduce. Then you can take it back tomorrow. You can take it. Bail petition stands allowed and disposed of. Therefore,
Lordship, I seek some short accommodation, Lordship. This matter we can take next week, Lordship.
As you wish.
On, this has Lordship on 28, Lordship.
Learned counsel appearing for the petitioner seeks an adjournment of the matter and prays for posting it next week. Prayer is allowed. We call for the available.
TCR receipt.
Scan case reports available, has already been received. List matter on
28, Lordship.
2810.
Obvious.
23.
Right, please, Your Lordship. So if your trial court records have come, a learned friend has to obtain instruction regarding service.
Also, we have not received instruction.
We're going to fix it on Monday, and by the time they may have.
Kindly get the instructions. Monday or Tuesday, we can fix it. though the scan record is available, but instructions not yet received by prosecution regarding service of notice upon the informant. The said instruction may be taken. This is the matter on 27. 27. then.
May please, Your Lordship. Yeah, earlier your lordship heard this matter and recorded those observations, lordship. Lordship may kindly see those orders.
Actually, Pranjal, my colleague, lordship.
Yeah, in this case.
May I
probably
call
that-
him
that-
lordship? He may proceed, I may call him lordship.
We can tell you, call him in the meantime, on another matter. Let him come.
Also some, look after by Pranjal Bhatta.
Other matters.
Lordship. So let me just,
Okay, I've seen the last order.
Yes, here my basic lordship that he was detained from 5/7/2025 night and he was produced on 7th lordship. And on 7th also lordship that
So
20.
the FIR says that, date is given as same.
Yes. FIR says because my submission is that from the detention period that 24 hours has to be calculated lordship. That other high court judgments are there, that it has to be calculated from detention period. So that 24 hours one submission lordship. And second is that lordship he was tortured.
Problem is that they don't record that officially.
No, it is in the reflected in
It
the
is there.
FIR itself.
If it is there, then it can be.
It is reflected in the FIR itself that he was interrogated in the police station. That page 17A, first paragraph itself, your lordship.
There is only the preventive detention and arrest.
Correct.
These are the two things.
Lordship.
There's nothing other than that.
Other than
no?
it.
Conviction is different thing.
Lordship.
So anyway,
And
we'll go into it.
And the other part, lordship, that his father's thumb impression was manipulated by the investigating agency, lordship, and according to that, he also submitted one application before the court also. That report was called, probably that report.
I don't know whether it has come. It has come.
That that jurisdiction from the session judge Sribhumi, it was called.
See,
That report probably office note is there, not there.
That report, my lord, I have received, my lord, regarding.
this is regarding scan TCR. Office notice regarding scan TCR, 810.
Lordship.
But one, my lord, as per earlier order.
Otherwise, it's a case of commercial quantity.
Yes,
commercial
commercial quantity.
That was recovered from the bank of that pond, lordship. Recovered from his, allegedly recovered from his house, lordship.
FIR is dated 6/7. right?
6/7. And he was
Just
arrested on.
the arrest memo.
Arrest memo, your lordship will find at page number 55.
55.
Lordship.
Yeah, now I remember. This shows as 7/7
7.
at 1:30 PM.
1:30 PM.
But according to your instruction, he was brought on.
No,
5th
not
only.
my instruction, lordship. In the FIR itself, it is written.
Let us see that again.
Lordship, page 17A, first paragraph itself.
Page 17.
A, 17A. This is, may I read?
He was interrogated.
Interrogated.
What is
And-
this, what is the relevant provision now of CR?
Now 187. lordship. 187
Morning we had.
and 58.
187 subsection. see, it uses the expression arrested and detained in custody.
Arrested
That is,
and
that is
detained.
the law actually. Arrested, a person has to be arrested to be detained, right?
So this lordship, because of the DK Basu judgment, subsequently Supreme Court said lordship that the detained person has to be produced before the magistrate. So that part was interpreted, and accordingly the various high courts held that for that 24 hours has to be calculated from the time of apprehension or detention.
Well, that is what I'm saying, that, this is what I mean, I was just saying, your
Lord-
point only.
Lordship.
That, it says arrested and detained.
Arrested and detained.
It
This
means
is
that a person can be detained only pursuant to an arrest.
arrest.
Right.
Yes.
Otherwise, anybody can be called for
Called for,
interrogation,
yes.
examination. Anybody, you, me, anybody can be called. But if a person can be detained only after arrest.
Yes.
Because otherwise, there's preventive detention. There's nothing in between actually. There are some judgments also, I think, where this practice has been deprecated. That the person is detained and then shown arrest later.
Yes.
Actually.
Those are judgments.
Because
Just
that
I'm-
period will be, illegal actually.
Yes.
But it may be difficult to prove also because there may not be anything in the record. Anyway, let us see.
But from here it is reflected that he was brought to the PS on the intervening night of 5th and 6th.
Was brought and interrogated.
Interrogated. And thereafter he was not released.
It does not say that he was detained. They own right.
No, that part he will be in the case diary, lordship. If he was allowed to go on PR bond, there has to be an entry in the case diary. And in fact, during these 2 days, he was severely tortured, and therefore, lordship, that he was not given that remand was also refused by the learned court, lordship. That order, page 21, lordship, may kindly see.
That's, I remember.
Yes. If he is arrested on page 21. If he is arrested on 7th, lordship, and he was produced before the court on the same day after 1:30, there is no question of torture. But here it was apparent from his body that he was tortured.
Page 21.
Page 21.
Yeah, I remember reading this.
Yes. Third paragraph and fourth paragraph.
Page 21. Anyway.
And earlier also, he was arrested by the same police station, lordship, because he previously filed one case against the OC, lordship. And when he produced before the magistrate asked the specific questions that your lordship may kindly see. It starts from page 27. That is regarding another case, but the conduct of the police station towards me, lordship.
Page 27.
Yes, it starts from page 27.
This was the case lodged against the.
No,
deputy
no, this was, lordship, I was picked up by the police because I have lodged a case against the OC, lordship, complaint petition filed.
This
by me.
complaint case.
Yes.
This complaint.
No, not this complaint, lordship. After the complaint petition, I was picked up in connection with a case, lordship. And in that case, the judicial magistrate had observed certain facts. And when inquired why this person was picked up, that IO says, that investigating officer says, because he lodged a case against the OC, lordship. That was reflected in the order itself.
Can you show me the page?
Lordship. That your lordship will find annexure 8, page 42. I'm sorry, page 42. And specific question that your lordship will find from page 45. Why arrest was necessary? That was the first question. And second question is important at page 46, first of lordship.
Yes.
It is reflected in the judicial order itself.
So he was arrested in this case due to.
Because of that grudge, I am implicated in the present case also.
Second time.
Second time.
Anyway, so
My lord, regarding, I would just like to point out your lordship, regarding that, my lord, first your lordship may kindly come to, my lord, page 57. My lord. I am just trying to point out, my lord, the tactics, my lord, which the petitioner is trying to, my lord, only taking advantage in his bail petition, how he is, my lord, doing all these things. I am just trying to point out that, my lord.
Page 57,
Initially, my lord, the first.
page 57.
In the first, your lordship, page 21, as he has pointed out regarding paragraph 3 and 4.
Okay. Page
Regarding his
21.
injury part.
Page 21.
Page 21, my lord, that is the order on the day of the remand, the order passed by the trial court.
Page 21. Yes, I am on page 7. Order dated 7.
Page 21, my lord, that is order passed by the trial court on third paragraph. That is only his allegation, my lord. On being asked about his physical condition, third paragraph, my lord.
Yes.
The accused person has stated, it is the submission of the accused, my lord, that SI Polasbora and one police official, Babul, physically assaulted him and inflicted severe injuries on his body, and also by inserting sewing equipment into his private parts. Accused has further stated before the court that he is afraid to disclose the names of the police personnel involved, as he fears that he may be killed if he reveals their identity. Regarding that injury part at the time of his production.
That's true.
But
it-
where is the injury, my lord?
it's
That is,
not-
that is only his submission, my lord.
Actually, this kind of allegation is made, it necessitates an inquiry actually.
Yes,
The IO should be asked to reply.
Yes,
Right?
ma'am.
If
And
necessary,
regarding that,
a
my lord,
separate medical examination
there-
has to be conducted.
Yes, my lord, whether thereafter, my lord, now, my lord, again, I will point out again, my lord, thereafter, my lord, regarding that, your lordship may kindly come to page regarding that inquiry, my lord. On the basis of the, my lord, second ground, my lord, he has taken that section 48 notice, my lord, served at that point of time, someone other has signed that 48 notice, not his father.
And kindly also address regarding that time, time of.
Time also, my lord, from the, my lord, case diary, I will point out here, my lord, everything has been mentioned
Okay,
by the
anyway.
IO.
So next, which page should I go to?
Page, my lord, 58, my lord.
Okay.
Regarding the, my lord, order passed by the trial court, page 58, last portion. As such, for proper inquiry, the complaint petition be forwarded to the learned Chief Judicial Magistrate, Sri Bhumi, for proper inquiry, treating the petition number so and so, filed by the petitioner as complaint. So now, at this point of time, what is the result of that inquiry, my lord? That inquiry report are initially, my lord, your lordship has called for that inquiry report.
You have got it.
No, my lord, that is from the registry, your lordship, my lord, on the first day of the, my lord, when the matter was listed, my lord.
I think we reiterated on the last occasion. Last occasion, it was not received, so it was.
Not received.
Reminder was sent also. I thought.
But if his submission that, my lord, that section 48 notice is not, my lord,
Not
that is
valid.
not the signature of his father, then, my lord, that, for that adjudication of that issue, my lord, that inquiry report is required, my lord, by the trial court. And secondly, my lord, now, my lord, thereafter, my lord, 2-3 times this matter again listed before this honorable court. Then IO also, my lord, submitted a report in detail, my lord, regarding these two grounds taken by the, my lord, the present petitioner. And my lord, in the, I have also the case diary, in the case diary also regarding that aspect, whether the, my lord, report of the, my lord, inquiry, IO is in, my lord, in line with the case diary, your lordship, everywhere, my lord, date, time, everything mentioned, my lord, when GD entry, my lord, was, my lord, entered in the police station, thereafter when again the accused person was called to the police station, thereafter when a search was made, everywhere, my lord, in detail, my lord, timing, date, and my lord, your report, your lordship may kindly in that respect.
Is the court report essential now? We thought it essential.
Yes,
that's
my
why
lord,
we
otherwise,
called
my
for it.
commercial quantity.
Because then we have to, because if suppose it is found on the basis of those inquiry materials or whatever, that the 48 notice has not been valid, then we
But,
will
my
not
lord,
go into 37.
but
right?
otherwise, my lord,
Otherwise, we'll have to go into 37.
otherwise, my lord, I am just trying to point out the conduct of the petitioner. Now he is trying to point out a case which was already registered in the year 2024, my lord. Now, what is the relation of that case of the 2024 with the present case, my lord? He is habitually involved in, my lord, using these tactics, my lord. Only for getting advantage in the bail petition, in this bail petition, my lord. And suppose, my lord, today this petition is allowed, then tomorrow someone other again come, on being identified, the accused.
Okay. They have annexed the GD
Yes, ma'am.
entries.
And case diary is also in line with the report, my lord, that is in detail, my lord, timing.
Can we dispose of, or you need that inquiry report, because that's.
Otherwise, my lord, considering all these, my lord, otherwise, my learned friend has pointed out during argument.
Because
that-
he has not made submissions on 37,
Yes, yes.
right? So we have to give an opportunity.
And for which, well, my prayer before, let's say, this is not a fit case on that ground to grant bail at this stage. And these are tactics, my lord. If suppose, my lord, on that ground, this bail petition is, my lord, allowed, then, my lord, anyway, tomorrow, my lord, someone other may come. How can police, my lord, ascertain that this person is the father of the present accused? On being identified by the other accused person, yes. He, my lord, stated that this is my father, then thereafter, my lord.
It is there
police
in the
will-
case diary.
Yes.
In the note, in the report of the IOJ, it has been mentioned.
Yes, yes. I will-
Your lordship, that identification of father, that I have not identified. They went there, they have served the copy. So it is their duty how they have identified the father, lordship.
According to this, their TOCA, they said that it is they are asked the accused.
Yes.
And the accused showed them
Yes, my
the
lord.
person as his
Otherwise,
father,
my-
and it was
yes,
given
yes.
to him.
Anyone
Some
may-
impression was
Yes,
taken.
my lord. If my lord, police
no,
come
that's
to my
what-
house, if I, yes, my lord, so, my lord said somebody is my father, then definitely police.
So
will take
admittedly,
steps
their
for-
case is now supporting my case, that the person who put the thumb impression is
No,
not
no.
my father. That is
No,
what they
that
are
is-
saying. Because if that is the same person, lordship, then why they are not going for the forensic examination? Because in my petition itself, I have
You
prayed
can see
before.
at the time of trial, this can be done.
Trial court has already passed order.
But now actually there has to be some materials to, anyway, so what should we do? Should we call for that, wait for that report?
No, my lord, otherwise it will, otherwise from
No,
from this, whatever materials available on record, my lord.
One option is there that we wait some more time for the report, and on the next date, the report should come. And on that day, both of you can submit on 37.
Otherwise, my lord, it will also, my lord, to decide adjudication of that, my lord, petition filed by the petitioner, because my submission is that is his tactics, my lord. Probably if, my lord, one of the case for delaying that petition may be the petitioner, my lord,
No,
later on.
if they have
Suppose
not,
that, suppose tomorrow matter will, my lord, suppose on that ground again matter came up before this honorable court, then he will again say that, my lord, that matter is still pending. On that ground, he will again pray for bail, my lord. So, my lord, it is his duty to, my lord.
What is your submission on 37? I appreciate that.
no, my case is that, lordship, firstly, the notice under section 48 that was not served to my father. That was my first submission before your lordship. On the first order also, your lordship reflected those things. Because that report was not coming, lordship, and I have paid for interim, therefore I have shown the other grounds, which is, lordship, that.
Kindly show, point out that page again regarding that, the supporting material in the case diary.
Yes, yes.
Regarding this.
Regarding the
report.
timing from.
No, timing I've seen, timing as well as that, thumb impression.
Thumb impression, that is 48.
With regard to A and B,
Yes, my lord.
then we can dispose it of perhaps.
If your lordship is taking a positive, view, then my submission would be, lordship may dispose it of. Otherwise, lordship, my main ground is that, lordship, that thumb impression report may be awaited.
That report. my
Because
lord,
Lordship,
because-
what they are saying, that I have identified
Because-
someone to be my father without verifying any document, they will hand it over and subsequently, Lordship, that plea can be. So that,
The person, the son will not identify a wrong person.
that in the police station itself, without seeing any document, how they can say, Lordship, serve a copy? It is their duty to verify that person. Lordship.
They have verified, my lord, they after.
And now when
verifying that
Lordship, I
notice was
raised the
served,
issue
my
that
lord.
I have not, I have, that copy were not served, so now they are taking another plea that the wrong person I have identified, again blaming me,
And my
Lordship.
lord, suppose, my lord, I am not, my lord, I am not admitting that, my lord, notice was not served to the father of the petitioner. Admittedly, my lord, notice was served to the, suppose, my lord, now the present the fact of the case is that, my lord, section 48 notice served, and his submission is that not served to the father of the petitioner. Somebody other has, my lord, signed that document. How, at this point of time, my lord, while he has filed an application before the trial court has also, my lord, ordered for an inquiry into the matter. That matter is already pending. So at this point of time, considering that regarding section 37 also, my lord, he failed to satisfy, my lord, to point out before your lordship that this is a fit case for granting bail, my lord, only on that point, my lord. So, my lord, at this point of time, my lord, on that ground, my lord, this is not a fit case for.
No, I have not argued on 37 because I have not argued on merit. If I argue on merit, then I have to argue on 37. If I should.
That's what I suggested, that you
Yes.
wait one more day for the report, and on that day, irrespective of whether the report comes or not, arguments will be taken from his side on 37.
My lord, because otherwise report has to be come from the court, my lord.
No, even if it does not come, next day we cannot wait.
Yes,
We cannot wait. Either it comes and because on next
Yes,
day,
yes,
irrespective of whether the report comes or not, hearing on 37 has to be given,
yes,
taken.
yes, that-
Parallel submission on 37.
Yes.
Then,
37 and 24 hours delay, that part over.
and kindly tag that,
yes,
that relevant materials in the case diary. You just put a this thing marker and
regarding, yes, my
write it. And regarding also that notice, thumb impression. Full stop. There was the previous order dated 14/10/2025. The report as called for is not yet received. However, the case diary is available. Full stop. Since the penal provision of NDPS Act given at this stage pertains to commercial quantity, therefore the applicability of the rigors of section 37 also has to be seen. Stop. So far, the submission of the learned counsel for the petitioner was focused more on the compliance aspect of section 47, compliance aspect of notice under section 48 BNSS. Stop. The learned additional PP submits on the basis of the case diary that there has been proper compliance with the said notice, and also the accused has been produced before the learned court after his arrest within the stipulated time. Just for reference, what was we have to. Next date, we'll do the hearing on 37. He has already submitted your part.
regarding,
Yes.
regarding that, regarding note that in presence of the, my lord, that is after the, my lord, pointed query by this honorable court, that, my lord, report, from that report, it reflects that in presence, he now submitted that, my lord, in presence of the accused person, my lord, exactly, my lord, the same line is not there in the case diary, but from the,
Broadly.
Yes, broadly, I will point out on that.
You can just mark it.
Another thing your lordship will also notice that page 59 and 55, one is typed copy and other is handwritten. Father's copy is handwritten.
I'll go through everything carefully. Let the hearing get concluded. I'll go through it. If necessary, I'll reserve it and go through it carefully.
Lordship.
Everything, right?
If any other facts are there, I will place before your lordship.
I'm just at a loss to find out which was the order we had sought for. Which was the order?
Lordship, at page 57. Because father appeared and submitted that that his thumb impression may be sent for FSL. Only thereafter they have pleaded that the wrong person has been identified by the accused.
Send it to FSL, best.
Yes, that is my
Expectation of both sides.
Yes.
Because this compliance, we want definitely, you know, the law requires compliance.
Compliance is that is my
Compliance
request,
with these procedural requirements, you know, which is a new law now in this kind of compliance. But we always need honest compliance.
Yes.
If there is no compliance, no compliance, no problem.
Yes,
Admit it, let them get the benefit of, next time you learn.
Yes.
But we cannot encourage any manipulation.
Yes,
right?
but how they can say.
I'm not saying that this is manipulation,
Yes,
but I have to decide,
yes,
I have to keep an open mind. There's contentions on both sides.
That identification
But,
part also your
No
lordship. will
question
see.
of giving any indulgence to manipulated compliance.
That
You have
identification
complied,
part.
fine.
Because if they
Not
blame,
next time.
yes, because if they say that the person whom I identified, they need not to go into further identification or verification, that will lordship create some confusion. That your lordship will see on the next day.
In terms of the order dated 2/9/2025, based on the petition filed by the accused, on behalf of the accused, the special court had forwarded the same to the learned CJM Sribhumi for an inquiry, treating the said petition within bracket petition number 423 dated 28/7/25 as a complaint. A report was called for earlier regarding the outcome of that said inquiry, if any. Therefore, issue a press requisition / reminder for a report regarding the said inquiry. Full stop. Along with this order, a copy of the order dated 2/9/2025 passed by the learned Sessions Judge Sribhumi within bracket Annexure 11 of the bail petition may also be sent to the learned court below for its maybe also sent to the learned CJM Sribhumi for the convenience of the court to submit the report. I am not seeking a completion of the inquiry, just
Yes.
status report.
Yes,
So that whether it throws any light on this.
yes.
At least that FSL report would have been better. Further inquiry will go on.
Forensic is such a highly evolved science, you know, always forensics can be made use
Well,
of.
my lord,
Yes.
compliance is must. But my lord,
Compliance
my difficulty.
I get your point,
Yes,
definitely.
my worriedness because somebody tomorrow, my lord,
Yeah,
again will come.
That should not be.
That
So
would-
there are some
There
issues.
should be, the court should be satisfied that there is compliance.
Yes,
You know, it doesn't have to be father, anybody
Yes,
who's
yes.
pointed out, who's,
Yeah.
he's nominated,
Yes,
actually.
ma'am.
That person is nominated.
yes,
Because the arresting person may not know the relative,
yes.
nominated.
Regarding the identification and how that notice has to be, sir, I will submit on that because that issue is already addressed by coordinate bench also.
List
That-
on, you suggested it, list
List on.
is the matter on,
After
don't take
any
it on
date,
30/31.
31. my lord.
No, don't take it on
Or
30/31.
30, then my lord, 4/11.
3 or 4, 4/11.
4/11.
On that day, we'll close this.
Yes.
Pablo.
May I please, Your Lordship? Lordship, the petitioner was arrested on Lordship 5/9/2025, Lordship.
Yes.
And as on date, Lordship, 48 days behind the bar, Lordship. The petitioner is a lady, Lordship. And the allegation is that, Lordship, from the possession of the petitioner, Lordship, intermediate quantity, Lordship, as per FIR, 25.9 gram heroin was recovered. And as per Caesar list, Lordship, 21.75 gram without plastic, weight of the plastic pouch. 21.75 gram was recovered. Case diary was called for, Lordship, on the earlier.
The case diary I have received, but as per the note of the IOML, in this case already search sheet submitted by the IOML. Regarding the present petitioner, FSL report, everything is there in the case diary. The petitioner is involved in this business. She is a peddler, my lord. She is involved in this business since, my lord, long. She is continuously involved in selling all these drugs, my lord, in that area, my lord. On the basis of the source information, police, my lord, searched the residence of the petitioner. Then thereafter, my lord, 25.09 grams of the heroin. Heroin recovered. 25.09 gram of heroin.
Lordship, regarding the, Lordship, there is no any earlier case of the petitioner is mentioned in the forwarding, Lordship. And Lordship, if the investigation is completed, Lordship, then for the purpose of investigation also the custodial interrogation of the petitioner is not required, Lordship. So my prayer is that she will face the trial, Lordship, to maybe allowed to go on bail.
Although, my lord, investigation completed, my lord, as per his submission. Although, my lord, at this point of time, he cannot claim, my lord, bail as a matter
From the
of.
diary, it's clear. Investigation is complete.
Yes, from diary, search sheet submitted.
Search sheet submitted. But the only thing is that involvement in peddling has been
Yes,
found.
Lordship, no earlier case was mentioned, Lordship. And I have annexed the Lordship medical report of the petitioner also, Lordship. She is suffering from stomach pain, Lordship. She has some infection on her stomach. Therefore, she was undergoing treatment, Lordship, before her arrest. And as per our instruction in jail also, she was undergoing treatment, Lordship. So considering all aspect, the petitioner may be allowed to go on bail, Lordship.
But we are imposed, conditions have to be imposed,
Yes,
proper
yes.
conditions. But otherwise, this. Heard. 483, we have application on the NSS application seeking bail for so and so. In connection with Bhorlumukh PS case number 132/25, the section. The accused was arrested on 6/9/25. The allegation is about recovery of suspected heroin,
Lordship arrested on 5/9/2025.
5/9/2025. And forwarded on 6.
Yes, no, Lordship.
Forwarded on 6/9/2025. The allegation is about recovery of an intermediate quantity within bracket approximately 25.09 grams, including of polythene from the possession of the accused person. Case diary has been received, which indicates completion of investigation resulting in charge sheet against the accused under section 21B of the NDPS Act. The learned additional PP, Mr. Bhattakur, submits that the investigation has not only found incriminating materials with regard to the present offense, but also it is also revealed that the accused has been involved in peddling of narcotic drugs since some time. Nevertheless, considering the completion of investigation, I'm inclined to grant bail to the accused, subject however to proper conditions. Accordingly, allowed to go on bail of 50,000 with one surety of the like amount to the satisfaction of the concerned learned court, special judge.
Kamrup Metro.
Special Kamrup Metro. And following conditions are imposed. She shall not abscond and shall be available to face the trial. Number 2, she shall not hamper or tamper with evidence. Shall not try to influence any witnesses. She shall not indulge in any illegal activities or any activities of consumption or peddling of narcotic drugs. Stop. In case the accused is found to be violating any or more of the bail conditions, the prosecution would be at liberty to move an appropriate application for cancellation of the bail. The return the case diary, bail petition stands disposed of. all these persons were, who have been allegedly found in peddling, that even after bail,
Yes.
after the investigating agency can keep an eye.
Yes.
If they are violating and again indulging, then you can always move.
Yes, yes.
The
Obligation.
councils will also tell, you also tell. It will.
No, please, Your Lordship. So today is the date fixed for CD, is there?
Yes.
Is there a receipt?
Receipt, no? Commercial quantity? Yes, Lordship, quantity is commercial, but my connection is not there in this case. Lordship, I am a godown keeper. Employed with a cargo company. So that cargo company transported a shipment 26.
26, my lord, case diary not receivable, sorry. my lord.
Which one? Gorchuk PS 235.
No, my lord, 26 is the one.
Kindly cross check.
The list also it is not available, it is mentioned as not available. But I thought subsequently it has come.
No. 26, my lord, Anup Pandit, my lord, case diary not received.
Anup Pandit, case diary not received. Gorchuk 235.
Interestingly, Lordship, some bail applications have been filed by the named accused and other co-accused before the learned session judge. So those cases are fixed on, bail cases are fixed on tomorrow and 30th respectively. Before learned session judge 1 and 2.
Usually the learned session judge comes to know, he will not take up.
Definitely,
because
Lordship.
the
Firstly, the
same-
CD was
no,
called
no,
from
other-
this honorable
Other
court.
accused can move, that is choice. But same accused will not be taken up.
Our case was filed earlier. So firstly, CD has been called from this honorable court. Called for from this honorable.
Matter was earlier listed on, my lord,
Yeah.
810, only once, my lord, 810.
Lordship was pleased to fix date on 13, but finding the quantity commercial, it has been fixed today. It was fixed today. Lordship,
The case diary is stated to be not yet received. Issue reminder for the case diary of Gorchuk PS case number 235 of 25. You have to call for it again.
Lordship, I am
Otherwise,
behind bars without having any involvement of myself from 78 days, Lordship. And today, tomorrow itself, one of the CDs fixed before the learned sessions.
Session judge.
Yes, Lordship. Tomorrow itself. In additional sessions, just
Probably
With regard to co-accused.
co-accused, Lordship.
Maybe for which, my lord, today we have not received the case.
Maybe.
But firstly, case diary was called for from this honorable
Case
court.
diary was, yeah. So what do you say?
311.
311 would be. After tomorrow, any date before the second date of bill.
But because the CD will be sent back
Yes.
and then it will come here. But if you can
It cannot be requisite.
coordinate, yes.
29, I will take.
29, we can take a chance. 29.
29, deeply understood.
For example.
Please, Your Lordship. Lordship, regular bail application, Lordship, case diary was called for.
27 CD received, my lord.
Lordship, Lordship will file the FIR on page 16, Lordship. Lordship, as per the allegation, Lordship, from the rented premises of petitioner number 2 and 3, 5 gram contraband was recovered, suspected contraband was recovered. Thereafter, upon their statement, from petitioner number 1, 8 gram was recovered. Lordship will find the inventory on page 31 also.
There are two petitioners hearing.
Three petitioner, and as of today, 57 days behind the bar. There's 60 days offense, Lordship. Whether investigation has progressed, Lordship.
That's
CD will review this.
5 grams of heroin.
Lordship, initially 5 gram, thereafter upon their statement, from the possession of petitioner number 1, 8 gram.
Here, my lord, all our family members, my lord, petitioner number 1 is the mother of petitioner number 3, and 2 is the, my lord, wife of petitioner number 3, my lord. And they are habitually involved in dealing with all these, my lord, killing of these contrabands, my lord. In respect of my lord, petitioner number 3, earlier 1 Hatigaon PS case number 25922, also under NDPS Act is also
Registered.
against petitioner number 3, my lord.
Also regarding that, nothing has been mentioned in the forwarding, Lordship. Forwarding report.
Repeat offenders are, very strict. That was earlier in point of time?
Yes, my lord, but date, my lord, when early, or 22, my lord, 2022, my lord, Hatigaon PS case number 259.
They must be in trial.
Under section 20B of the NDPS Act.
Heard so and so, 483 maybe.
As per the note of the IO, my lord, in that case, my lord, that case is pending before the district and session judge, Kamrup Metro, as the case is at the stage of appearance, and the petitioner number 3 has not appeared.
Has not appeared.
Yes, yeah, Lordship, my lord.
Lordship might not receive any summons, if I'm not aware, Lordship. I do not have any instruction regarding that, as it
Have
is
to
not
issue
mentioned in.
production warrants, he's in jail,
Yes.
right?
Lordship, 57 days already, Lordship.
This cases don't deserve bail because it will reduce
Considering the
stringent conditions,
stringent
the
condition may be imposed.
actual police, actual data, investigative data is there from the ground. That during the period when the peddlers, especially the peddlers are in detention,
Yes.
for a particular period, in that particular area, during that time they are in under trial detention, the drug consumption decreases.
Yes.
Such is the effect. Anyway, I'm granting stringent conditions.
Stringent condition.
And the most difficult thing is that most small-time consumers are also small-time peddlers because they realize the money through pen generally. 483 BNSS application. So and so, Hatigaon PS case number 160 of 25 under section so and so of the NDPS Act. Petitioners are stated to be all family members. The allegation in the FIR dated 28/8/2025 is about recovery of 5 grams of suspected heroin from Rohima Begum and subsequently on us, Rohima Begum and subsequently on our statement, recovery of another 8 grams from Rohim Ali and Muskur Begum. Full stop. The case diary has been received. The learned additional PP submits that the investigation has lent support to the allegations in the FIR, indicating the involvement of the present, of the persons, the petitioners, in peddling of drugs. It is stated that, it is submitted that with regard to Rohim Ali, another case is pending against him under NDPS Act before the court of the learned session judge Kamrup Metro. Investigation must be over, as FSL report is pending.
FSL report is pending.
The investigation is stated to be pending for the FSL report. and other parts of the investigation appears to be over. The given situation, I allow the bail subject to suitable conditions. All the three petitioners are allowed to go on bail of rupees 50,000 each, with a surety of the like amount each, to the satisfaction of the concerned learned court, special judge, special judge NDPS, Kamrup Metro. So the following conditions are imposed. Number one, they shall be available for trial if one commences. They shall not hamper or tamper with evidence or try to influence any witnesses. Number three, they shall not indulge in any activity of peddling narcotic drugs. Stop. In the event of violation of the bail conditions, the bail would be liable to be cancelled. Return back the case.
Deeply obliged.
Itu ta asan. Our leftover kiba asan? Timing kiba asan?
Map is lost. Well, in this case, a medical officer lordship is in judicial custody for last 42 days lordship. My lord, on the basis of my lord statement of co-accused lordship, my lord, who was engaged by the superintendent of the hospital lordship to my lord drag the petition in case lordship, he was arrested lordship. Now, kindly see the page 14 is the FIR lordship. Well, that particular lady, Rehena Khatun.
Page 14?
Yes, lordship. My lord, she was the accused lordship. Now, superintendent of hospital lordship lodged FIR lordship against her, saying that she was, my lord, writing some certificates in the office of the petitioner lordship. On the basis of her statement, lordship, that the petitioner
He was arrested.
no, kindly see page 17, lordship.
On the basis of her statement, he was arrested.
Yes, lordship. On the kindly see page 17, lordship. Initially, the IO, my lord, while paying for my lord, the police custody lordship, objected bail lordship. Now, after 2 days police remand lordship, he was reproduced. Kindly see page 17, lordship. My lord, second paragraph. Married lord. During the interrogation at the remand period, accused persons has disclosed so many clause related with this case. I therefore returned back the accused person after completion of police remand period as well as completion of interrogation lordship. My lord, as per my IO lordship.
2 days have been taken, thereafter not taken.
Lordship.
2 days police remand?
Yes, lord. Thereafter not, no prayer was met, lordship. Now, this is the Honorable Supreme Court lordship. In a case, my lord, that is P. Krishna Mohan Reddy lordship, recent judgment lordship, has stated that for the purpose of bail application.
See that, let's see the investigation first.
Yes, my lord, case diary received, my lord, the FIR is lodged by the
Give me in the meantime. Yeah.
FIR is lodged by the superintendent of that hospital, my lord, and he is the senior medical officer of that hospital. The present accused person is
FIR is lodged by superintendent.
superintendent of the civil hospital, and the present accused person is the senior medical officer. And regarding that allegation, my lord, some of the statement of the, my lord, witnesses is also there. Witnesses implicated the present petitioner, my lord. And during investigation, police seized, my lord, total 17 numbers of age certificate, my lord. Although in that age certificate, at that point of time, signature of the present petitioner is not there.
Not there.
And why that at that point of time signature was not there, my lord, his statement is, the present petitioner's statement is available. Otherwise, some materials is there against the accused persons, and witnesses implicated that the other accused persons, my lord, lady, my lord, he worked on behalf of the, by sitting in his, my lord, office chamber, my lord, she is doing all these.
My lord, sir, my signature is not there, then why, my lord, I should be held responsible, lordship?
Because other
My
statements.
lord, only on the basis of her statement, she was engaged by the superintendent of police, sorry, hospital.
According to the investigation, he is also implicated.
Yeah, yes.
But
Not only the
just
present.
fairly submitted. Now the documents he does not have his signature.
Yes, lord.
Let him go at this
Yes,
stage.
sir. Since 11/9, he 43 days.
Let him. But these are in,
It is not that only is on basis.
PC Act is also given.
Yes, yes, PC Act.
That is why the learned court below did not,
Yes, yes,
did not take out the matter.
added, my lord.
Ichhe Ahmed, learned counsel. P. Pothakot, additional PPE. 483, real application. Gwalpara PS case number 175 or 25 under section so and so. Read with section 7/13 of the PC Act 1980. The case arose out of an FIR dated 10/9/25 lodged by the superintendent of the civil hospital Gwalpara with the allegations that the Rehana Khatun named in the FIR was collecting money from patients and issuing certificates fraudulently. Full stop. It is alleged that she has been carrying out these activities sitting in the office of the senior medical officer come district nodal officer, Dr. Nazir Hussain Khan of the hospital. Though, full stop, though the allegation, though the basic allegation in the FIR was directed at the said Rehana Khatun, but the present accused was also arrested during investigation on 11/9/2020 and presently in judicial custody. The case diary has been received. The learned additional PP submits that the investigation in the nature of the statements of several witnesses have also implicated the present petitioner. However, it is fairly submitted by the learned prosecution, but the police during investigation has seized several number of documents and certificates, and that the signature of the present petitioner was not found. Signatures of the present petitioner were not found in the said seized documents. Investigation is not yet completed. Nevertheless, in the circumstances, considering the progress of investigation and the length of detention, the accused so and so is hereby allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the concerned learned court. CJM Gwalpara.
Lordships, it will be special judge Assam Lordship. PC Act is there.
Oh, yeah. It has been transferred. The concerned learned court within bracket learned special judge Assam. Subject to the conditions that he shall be available for trial if one commences, he shall not hamper or tamper witness or with evidence or try to influence witnesses. Violation of bail conditions might entail cancellation of the bail. Return case diary, bail petition stand disposed.
Obliged, Lordship.
Take 2 minutes break.
My lord, case diary received, regarding at the time of granting interim, my lord, at that point of time, petitioner has raised an issue regarding, my lord, section 14 of the Immoral Traffic Prevention Act, my lord. Here the petitioner was arrested by the sub-inspector of police, my lord. So on that ground, petitioner is in interim, my lord. Your lordship may fix.
DSP?
No, my lord.
It's a special officer.
Special officer has to be appointed in that area, or otherwise he has to be authorized.
But that was not there.
Special officer and authorized officer has to be not below rank of DSP, something like that?
No, Lordship, he should not-
SI can also.
SI.
SI can also.
SI, but
authorized.
Not
yes,
SI,
not-
not.
SIP
SI,
is not authorized.
Not SI,
Oh,
my lord,
probation.
inspector, not sub-inspector, inspector, my lord. Inspector. So, my lord, regarding other aspect, my lord, while along with that, my lord, Immoral Traffic Prevention Act, IPC provision is also there. So, my lord, I will have to go into, look into, well, there are some Supreme Court decision is in this regard. If, my lord, along with Immoral Traffic Prevention Act, if IPC is also there, in that case, my lord, what need to be done, my lord? So,
You need some time.
yes, I need some time to.
We will extend the interview.
Yes, Lordship. Otherwise, Lordship is already released on bail now, the issue raised in Lordship.
Anyway. when should I fix it? Take some time.
Already he is in interim on,
411.
yes, for,
But you have to keep the CD.
yes,
You'll retain the CD.
yes.
The file order dated 19/8/25. The accused was granted interim bail for the reasons stated there. The case that it is submitted by the learned additional PP that though the case diary has been received, but he needs some time to study certain aspects of the matter, especially with regard to arrest by empowered officer when other IPCs, when other penal law provisions, other general penal law provisions are also involved. Prayer is allowed. Case diary may be written. Interim bail dated 19/8/25 stands extended till the next date of listing.
Can it be on 5 of November, Lordship, and the 4 is a motion? Lordship,
Fifth is holiday.
5 is a
Fifth-
holiday.
5th is holiday, then 7, 7,
6,
7,
7th.
7.
we are at fixed it on 4th. You tell me 3rd,
Yes, my lord, third.
3rd? Will be all
Yes,
over
yes, sir, 3rd.
11th.
I live.
Good was.
May please, Lordship. Lord, the last occasion in Lordship was pleased to appoint an amicus curiae, my lord. My learned friend is there.
Yeah. You are there, Nemis?
My lord.
Lord, the only thing is that, Lord, the petitioner is behind the bar since 5/3/2025. Already 231 days have been gone by. And my lord, the informant and the victim girl, they have been examined, my lord. So just to put forward my defense, my lord, trial is going on.
Yeah.
My lord, appreciate.
Occasion, your lordship is directed to take instruction lordship for the
Services.
service
For that.
upon response to hidden serve or not lordships. Otherwise, lordships, 102 days in custody lordships, section 8 is there lordships. Friends, lordships. Maximum punishment provided under the said section lordships, not less than 3 years and up to 5 years lordships. Now he is in 102 days in custody lordships. And moreover, lordships, his wife is suffering from the cancer lordships. I have also annexed the medical documents lordships.
Instruction has been received. Service.
No,
is there.
no, no. We have not received instruction.
First two occasion lordship.
TCR is already there. It is there.
Lordship, but on service, regarding service, we have no instruction, Lordship.
Let's decide this first. This aspect is there. I don't know whether bail can be given or not.
Lordship.
That's another matter, but we'll expect that because this has been recorded. His wife is suffering from cancer. And whatever it is, needs to be, you take instructions.
Lordship.
The instructions regarding service upon informant not yet received. The prosecution shall take the instructions by the next date. This is the matter on
Monday.
Monday could come.
either
On 3rd November, Lordship.
3rd November, oh yeah, 28, 29 or 3rd?
3rd, Lordship.
Can you just order that lordships?
29 or 3rd?
29 then.
29.
Oblige lordships.
Hearing.
My lord, in respect of, as per the order dated 17/10, the amicus curiae was supposed to be appointed, but it was not.
17th.
17/10 order,
Okay, no, service was not complete. sir.
Service was not completed.
That was the reason.
So that
Let
is
us
why
see.
they obtained
Service.
instruction from telephonically.
Not, sir, no instructions received.
No instruction, Lord.
Amicus curiae may be
Amicus may
appointed.
be appointed, Lordship, other.
No, no, service is not complete. How can you-
Lordship. Then we have to take instruction, Lordship, on that.
My lord, last 2 days already is over for taking instruction.
That is,
On
that
the
is-
last occasion, they have
That is search grievance, that is pending for that. Otherwise, we are ready.
Lordship,
The scan copies also are available.
Lordship.
Scan copies, yes, it is available.
Yes.
Which police station? Agomoni, I don't know. Which district? Agomoni?
Agamoni Police, Dhubri.
In Dhubri.
Yes, Agamoni.
Can you take the instruction, if I fix it on Monday?
Lordship, I can. I can, Lordship.
I got to understand what it is. The instruction regarding notice upon, notice upon the informant not yet received. The prosecution shall take the instructions by the next date. List the matter again on 28/10. Sorry, I said 27 or 20. 27 or 28 will be better.
Any date, Lordship. 28 will be better, Lordship.
28/10.
Item 70, my lord, same order.
Item given?
Item 70.
That's 70, my lord. Out of the same FIR, my lord.
Item 67 and 70. Same order.
Same order.
Same order.
Wait, please, your lordship.
Just a minute.
Number 70. Earlier was along with 70, no?
70, yes.
In 70, we have a service report, Lordship. In item 70, I have the service report, Lordship. It is completed.
Then in this case also it will be. same.
Okay, if it is attacked with a similar case, Lordship, then it is completed then.
It will do.
Then we, amicus curiae may be appointed then,
Yes,
Lordship.
Then we can. I got to deduction.
PS case is same, Lordship.
67, no. PSS case is same. Different accused.
Lordship, then service completed, Lordship.
তাহলে হলনি হবো 67 90 তাহলে একটু কাটি দিও it is submitted by learned additional people KK Das that service upon the respondent is completed. But since none has appeared, an amicus curiae may be appointed. Is S. Nawaz, learned counsel, is hereby appointed as amicus to represent the informant. Order about it. Which date we fixed?
On 28, Lordship.
Oh, yeah. On that day we can hear.
Lordship.
Today, in any case, they will have been time constraint. Right? So, 67 or 70. 67 and 70.
67, 70.
It order. Report received. This thing. Service is complete. Amicus appointed. Yes, no, the name of the learned amicus may be reflected in the court, and the petitioner shall furnish a copy to him, to the learned amicus. No, so you take a copy, the sir has to be told, Mr.
Oh, Lordship, I will.
Because he won't know, no?
Lordship, I will.
Convey that you will give him a copy.
I have the number, Lordship, I will call.
68.
Wait, please, your lordship.
68 and 71.
68 and 71.
68 and 71, my lord. One is BA and one is ABA.
Yeah.
Your lordship, yesterday it was kept for determination on 27A of the NDPS Act. So
27 caps here.
indeed, 66 days intermediate quantity behind the
Quantity
bus.
is intermediate, but they have added 27.
Indeed,
Yeah,
your lord. It is 38 years old petitioner. And the place of occurrence is 80 kilometers away from her house. Everything was found in her brother's house and nothing is related to her, even in the records of the court, your lordship, or the police investigation. Now, your lordship, with regards to 27A, not even one single element is there which directly connects us to any kind of financing, your lordship. And therefore, we
There is a very stringent provision.
Indeed,
Natural.
Indeed, your lordship.
If someone is financing drug trafficking, obviously
That,
it will be.
to that aspect, we are in no way connected, your
You have to
lordship.
always see.
Indeed.
Otherwise, my lord, in this case, investigation is still going on regarding that, my lord, 27A, my lord, from the residence of
Toibur.
petitioner number 71, my lord, Toibur Rahman, those my lord trucks where contrabands were recovered, and the present petitioner Moriam Bibi is the sister of that accused, my lord. And both the accused persons are source information is that they are not only involved in peddling those contrabands, but my lord, they are also financing, and thereafter, my lord, taking those transporting those my lord, contrabands from Dimapur to various places of Assam. And this is on the basis of that source information, my lord. Initially, those accused persons were arrested and those contrabands were recovered. And still now investigation is going on, my lord. So what further investigation will reveal, my lord? Till now, my lord, source information is that they are not only involved in peddling, but also, my lord, financing. And an amount of rupees 58,430 recovered from the residence of Toibur Rahman, my lord. And Moriam Bibi, my lord, the present petitioner is in jail since 18/8/25.
Your lordship, to that effect, the house belongs to my brother, that is the petitioner in the anticipatory bail. I am married to another person who is 80 kilometers away. My current residence, permanent residence is 80 kilometers away from the occurrence. My brother was not present in the house. My only misfortune is that on that particular date, I was present in his house. And the entire recovery happened from his possession, his house. I am in no way associated with it. And moreover, your lordship, not even one single money or financial transaction can be linked to me in any manner, your lordship. So therefore, we are humbly submitting that this does not come to us as a accused petitioner, your lordship. Other than the source information, there is nothing against us. Nothing, any statement has also not led to any discovery which could connect us to 27A, your lordship. Otherwise, possession also is not from me, from the house where I was found present because my brother was absent at the time of the raid, your lordship. And that is not my permanent residence, that is not my temporary residence. It is 80 kilometers away from my permanent residence, my place where I'm married to, your lordship. So that is our humble submission that we are not connected with 27A. The other part, on the same day, already 66 days behind the bars, your lordship, 38 years old woman, there is no flight risk, there is no, we will participate in the trial, and there is nothing for which we will evade the proceeds of law, your lordship. Therefore, currently our humble petition may be considered, your lordship.
FSL report, my lord, in this case not yet received.
FSL received yesterday, it was received. Yesterday FSL was available, your lordship.
Generally speaking, addressing my query to prosecutor,
yes.
Generally speaking, don't you think, fairly looking at it, that only source information may not be sufficient to attract such a stringent provision, right? 37. That bail is closed once,
Moriam
But
Bibi,
and then only 21 remains, the latest is.
well, considering length of detention, Moriam Bibi may be considered, but at this point of time regarding
The
Toyibur,
other one is anticipatory.
the Toyibur Rahman from his residence. my lord,
But 27, except for source information, no other materials.
At this
so
point,
far.
my lord, anything may not be recorded regarding 27A because investigation is still going on.
So far.
Only regarding Moriam Bibi, only considering length of detention, my lord, she may be allowed. And regarding Toyibur Rahman, my lord, anticipative only, he is not entitled for getting bail, my lord. At this stage, my
Can
lord.
I have a look at the CD?
Yes.
Twenty-seven A may be affected even if there is no elaborate bank transaction. Although if there is anything like that, that's very good for the prosecution.
Till
But
now, my lord, there is.
suppose giving money to someone to buy and then sell.
Yes, my lord, regarding
That
that
will also
aspect,
invite.
till now, my lord, regarding that aspect, there is nothing in the case. No, FSL report, my lord, I'm sorry, my lord, there is separate sheet, my lord, FSL report is.
That means investigation is it's ready to be charge sheeted perhaps. Cash of 58,000. Doskar Learned Council at hand. PP, P. Bhathakur additional learned additional fee. The 483 applications, before partially given. Seeking regular bail for accused petitioner Moriam Bibi, arrested on 18/8/25 in connection with Lanka PS case number 174 of 25 under section so and so of the NDPS Act. First of the allegation in the FIR dated 17/8/2025 is search of the house of the petitioner's brother Toibur Rahman, and the search revealed 31.27 grams of suspected heroin along with vials, full stop, cash and some plastic vials were also recovered. The present petitioner was also, present petitioner, who is the sister of that other accused, was also found present in the same house. Full stop. It is submitted by the learned counsel that the residence of the present petitioner is located more than 200 kilometers
No,
away.
Your Lordship,
in
80
the-
kilometers.
80 kilometers
80
away in the district of Karbi Anglong. And that she denies the allegations against her. Since one of the penal provisions given, section 27A of the NDPS Act, the applicability of the rigors of section 37 of the Act has to be seen. The case diary has been received. The learned additional PP submits that there are implications against the present petitioner as well about being involved in peddling of narcotic drugs. May be mentioned here in that as far as the quantity of the suspected contraband is concerned, it falls in the bracket of intermediate quantity of heroin. Full stop. Regarding financing of illicit drug trafficking, inviting section 27A of the Act, the learned additional PP fairly submits that so far the only incriminating materials in that regard, with regard to the petitioner, is the source information. Stop. FSL report has also been received. It appears that investigation is almost completed. Further, in my considered view, mere source information may not be sufficient to apply the full rigors of a stringent provision like section 37 of the Act, which practically forecloses the option of bail for the accused in the foreseeable future. Full stop. Therefore, on the basis of the existing materials revealed by investigation so far, I do not hold that the test of section 37 of the Act is passed in favor of the prosecution. Therefore, there will be no statutory bar to grant bail to the accused. Considering the progress of investigation and also length of under trial detention, the accused can be granted bail at this stage, subject to suitable conditions. As the materials prima facie indicate her involvement in peddling as well. Accordingly, the 50,000 with one security, the satisfaction of the concerned learned court. Special Judge Hojai.
Hojai.
And subject to the conditions that she shall be available for trial upon commences, shall not hamper or tamper with evidence, shall not in any manner indulge in any illegal activities, including any activities of drug peddling or consuming prohibited by the NDPS Act. In case of violation of any or more of the bail conditions, the bail will be liable to be cancelled.
Yes.
the instance of the prosecution or the IO.
Much obliged, your good sir.
Return back is the bail petition. But this AB, I think,
Yes, my lord,
Not
from
been
his
justified.
person, my lord, from the residence of the present.
AB is not, you take back the FSL report.
Yes,
এইটো লিখক মই AB টো মিলাই দিম চেম্বাৰত কৰি দিম AB এটা আছে কানেক্টেড 71 টো মই মিলাই দিম পিছত ন দিস ইজ এইখিনি লিখাৰ পিছত এইটো পিছত মই বাকীখিনি কৰি দিম
Deeply obliged, much obliged, your lordship.
No, no, AB I'm not considering this I'm
Much obliged, deeply obliged, your lordship.
dispose
Much obliged. your lordship.
last part টো বেলেগ হ'ব খালি
14, my lord, till now, I have not received any instruction regarding service of notice.
What was 14?
Your lordship may kindly fix it on Monday, my lord, I will try to get the instruction regarding postco, my lord. Service of notice to the.
Oh, service of notice. Service report upon the informant not yet received. Prosecution shall take press instructions. This is the matter on 28,
Oh, 28, yes, sir.
2810. You're almost through it.
Please, your lordship, as per official 6/9/25, service upon the respondent number 2 is complete, lordship.
Just like that.
6/9/25.
49. Office note dated
6/9/25.
the POXO matter.
No, lordship. Not
What's
POXO, lordship.
washing? Learned Counsel, your good name?
P. Soria.
Learned Counsel draws my attention to office note dated the date of the office note.
6/9/25.
6/9/2025, indicating completion of service upon respondent number 2 plus the private respondent. Respondent number 1 is the state. Full stop. Represented by the learned additional P. Scan record has been received,
Yes, lordship. That was received.
already received.
Yes.
It is also submitted that the scanned case record has already been received. Full stop. So we are ready for this.
Yes,
Wait
sir.
for someone, they can appear, someone can appear on the next. This has been admitted or it will remain at the admission column?
Admission column.
All, this is the matter on so and so date in the admission column.
Till then, interim order pass earlier.
Interim, yes, that will come. Interim order is the interim order granted by order dated 21/6/2024 shall stand extended till the next date of listing. This is the matter on, you take it, when should we fix it? It's 23 matter, right? So November 3rd week, is it okay? But you can appear me. November 3rd.
Date may be fixed. also.
These 20/20/2011.
Uploads.
Is the matter, Mr. Roy?
My lord, this is our application under section 311 was rejected for recalling of the witness under section 311, my lord.
Come for orders. For
The last order may be seen, my lord.
No, this was for paucity of time, last order. The previous order may be service of notice complete. Office note dated 4/9/2025 indicates service upon respond number 2. And the same is also reflected in the previous order dated 11/9/2025. Full stop. However, none appears today on behalf of the respond number 2. State is there, no?
Yes, state is there.
Prosecutor is there. It is also stated in the order dated 11/9 that if there is no appearance of respondent number 2, on behalf of respondent number 2 on the next date also, the matter would, the court may proceed with the matter. Stop. So anyway, it is, it is at the stage of admission only, not yet admitted.
Admission,
So-
at the stage of admission, lordship may fix for admission.
We'll fix
and
it for
hearing.
admission only.
Because this is, we filed it long time back, my lord,
Uh,
on 24, my lord.
Yes, yes.
And there is no witness also come in the trial court also. Because 3 witness, my lord, 3 witness are the relatives, father, brother and mother, my lord.
Okay.
And we want to recall that witness, my lord, for
Cross-examination.
cross-examination.
But it was
For
disallowed.
the- Yes, yes.
Disallowed. Anyway,
Law is very clear, my lord. I place judgments, my lord. Lordship may fix, maybe
Today.
today is not possible. I think.
There's a full court meeting also.
Right, right, right.
I have to rise, sign some orders.
On fourth
That's at
number, my lord.
4:45, but that will be, yeah, please,
On 4th number, my lord.
4th November. So in that week, we can fix in the 4th or 6th.
6th, my lord.
6th.
6th now.
List the matter on 6/11/25 in the orders, in the admission column. Right? It's not yet admitted, right?
Not at admitted, my lord.
Admission column.
And then disposal, I'll, because for this, the
possible.
trial is also my
If
lord.
possible.
Yes, obliged.
Find it difficult to reach actually. That's all. Okay. I don't know, man. I think other matters you have to make a mention only.
I beg to mention item number 55, 56, and 57, madam.
Just come to that. 55, 56, 57, hearing matters.
Hearing matter.
Hearing too, we could not start also.
IA for my lord, deal my lord, also pending.
55, 56, 57. You are amicus
Yes,
for the informant?
Yes, Lord.
May fix on my lord 28, 10, my
No,
lord.
no, it will not. Let it be, 24 matter after that. Next week, beyond next week, the 55, 56, 57 will not be taken up. Couldn't due to paucity of time, my lord. Stop. You are appearing as amicus in all the matters.
Yes, Lordship.
all
It-
three
it-
matters.
It arises out of the same
Same,
case.
same. Case.
30, my lord.
P. Agarwal
Dr. P. Agar.
has appeared as amicus on behalf of the informant. No, I cannot. List the matter for hearing on,
3010.
suggest a date.
3010.
Non,
Since your Lordship is saying the next week, 4th or 6th in,
next week, because it's fixing is easy, reaching
Yes,
is mostly.
yes, Lordship. In fact, these matters were listed last week also.
Don't know. We have to find some solution to this. 13/11.
Lordship.
Because I have experimented, if I take admissions have to be taken because people keep waiting. Then orders I cannot touch. If I take orders, I cannot touch it. So need more space.
Lordship, 30,
13, Lordship.
13/11.
Lordship, item number 72, my lord. The service has been returned back because it was taken usual process as per order, my lord. Now, my lord, I would like to take a fresh step with register post, my lord.
The petitioner shall, paucity of time, however, petitioner shall take fresh steps.
With
for the,
register post.
Respondent by registered post.
Uh,
AD does not come back now.
Upon respondent 1,
Point number 1.
I love that.
Is the matter
On,
after
after
3 weeks?
2 weeks.
After 3
2
weeks.
weeks, 3 weeks.
After 2 weeks in the orders column.
Lordship.
Right.
Obliged, lordship.
Sometimes it is better to leave the date open also,
Yes.
because registry actually knows.
Lordship.
Sometimes
Obliged.
you should fix, sometimes you should keep it open.
Highly obliged.
Right, item number 51,
Yes.
52 and 53, these
Yes,
are
yes.
actually connected appeals, my
Yes,
lord.
yes.
2023 appeals, then we are in custody, my lord. 51 and 52, they are in custody. And your lordship had heard it to an extent on the last occasion, it came up last week, where I had submitted that this is a case which would be remanded back because of non-compliance of 330.
I had heard it. No, no,
Yes,
it's not part heard.
Not part of, my lord. The lordship had taken it up for only a moment, my lord, because there was
Oh,
no
yeah,
time.
that 313.
313 thing, because they had asked the entire bulk
Oh,
questions,
so-
my lord. So may I pray, my lord, it may come up on 18th, my lord, as a fixed item. And if possible, my lord, as top of the list, my lord.
51, 52, 53.
53, my lord, because these are
Paucity of time, so in this matter, it is submitted that the appellants are also in custody, this matter. Intake order, this is the matter on 1811. How to direct this top of the list? What,
That can be
what
reflected in
exactly
the-
it means actually?
Then it will come up first thing in the morning, my lord.
In the morning. But can it be allowed like that?
That is done, my lord.
Sometimes.
Practices, sometimes.
But,
Because this will not take much time, my lord. Only thing that your lordship will see is the 313 statement, because we won't be going on the merit, my lord.
okay,
Or
let's
at
fix it.
two, my
just-
lord,
Oh,
at-
yeah,
at
that
2
we can
PM.
fix. Fix it, let us fix it on 1811, and on that day, will you make a mention? We'll
At
try-
two,
try-
if your lordship may direct it at 2, my lord. that-
endeavor would be made to take up the matter at 2.
At 2.
Lordship-
Deep.
Lordship, item number 60. So please fix after 2 weeks.
60, it is 5960, I think.
60 only.
Is it, oh, sorry, no, that's valid. 60, paucity of time, list after 2 weeks.
2 weeks.
Yes.
What is item number
How much?
58, that may be fix a date, my lord, in the next month, my lord, any date.
Next
58.
month,
Yes, my lord.
611. 611, list the matter on 6.
Lordship, item number 73.
Yes. 73. Yeah, tell me. What is, it's for orders, no?
Yes.
Okay. Should you want, I don't know why it came.
Lordship,
Because
as
I have
per
not
the
opened the file. No, no, I have not seen the file, so why it has come for? Can you tell me?
next week,
Because I have not opened, I not the file. File,
73
73, paucity of time, what is the matter?
orders.
Anyway, it doesn't matter.
Services in the
Service report is edited, Mane.
wait, it only the you say.
Lordship, service report is edited.
I'll check, don't worry. Service report is still awaited. Well, no, yeah, paucity of time, and it comes now, a lot of things. Await. This is the matter in the orders column. After 2 weeks or 3 weeks, right? 3 weeks.
Applies.
You want me to fix a date? I'll fix a date. The 3 weeks only, you know? October, 5 days. It will be on 13/11.
Applies.
May I please have lordship, item number 59, lordship, today morning I had mentioned this matter 59, so can the matter may be taken on next week at 2 any date, lordship?
59. Again, paucity of time, it fix it on. And 11/11.
Lordship,
11/11.
At 2, lordship.
Endeavor
because,
would be made to, on the prayer of the council, endeavor would be made to take up the matter at 2 p.m. We have to,